Adjournment আছে নেকি? Adjournment আছে. Item 1 for motion. Mention.
Lordship, covered with similar issues already disposed by your lordship on page 74, my lord. And on 20th, lordship has similar order. Okay. Elementary and effective.
Yes, Lordship, it was addressed to Minister. They want to give it to the Secretary. Yes.
Heard Mr.
Jail.
J. Loskol and Council Petitioner, Mr. B. Chaudhary for SSA, Mr. A. Fukan for Elementary Education Department. The petitioner claims that the issue raised in this petition would be covered by the order dated 23/6/2023 in WBC 3667/2023, and a similar order may be passed. The order dated 23/6/2023 in WBC is extracted as below. As provided in next paragraph, as provided in the order dated 23/6/2023, the petitioner may also submit representation before the Secretary to the Government of Assam in the elementary, and in the event such representation is submitted, the same may be a reason order may be passed on the same. Disposed of in the above terms.
Item 2.
Yes, Mr. Bezburwa. Notice issued or not?
Lordship, that
Law Examination Center change made.
Oh, that somebody married. What can be done?
That inherent power in the last occasion.
That the only VC only inherent power.
Under section 8B.
And
it should be read with the General Clauses Act.
You submitted that.
So section 21.
21 of the General Clauses Act.
And Assam General Clauses Act 23.
23. So Assam General Clauses Act. Assam General Clauses Act.
Section
23.
It will be better if there is a General Clauses Act.
Make an application to the Vice Chancellor. We'll observe.
Lordship, there is a technical defect, Lordship, that PC was not in maiden party. PC and the.
You don't have to make him a party. We'll provide. Make a representation, and Vice Chancellor may, in exercise of that power, may use his discretion and pass an order. We'll go to that extent. Heard Mr. H. Bezburwa, Learned Counsel for the petitioner. Also heard Mr. P.J. Fukan, Learned Counsel for the respondents in the Guwahati University. Mr. S. Bhuiya in the Higher Education Department. Anybody else?
Principal dispute.
Considering the nature of the grievance raised, we are not required to hear the principal of Dispute Law College for the time being. The petitioner, number one, why two petitioners?
Lordship, two is an husband, one is an wife.
Husband, we not required.
Lordship, he is also final year student.
So husband also wants a change of center.
Lordship.
Husband, we don't know. Husband will tackle his own problem. We are concerned with this lady
Lordship.
who may be inconvenienced. The petitioner number one is originally a student of the LLB course in the Dispute Law College at Guwahati. While she was undergoing the course, she got married to the petitioner number two, namely Akhlasul Ahmed, who is a resident of village Kanoimara, part 1, under police station South Salmara in the South Salmara Mankacha district of Assam. And after marriage, she is residing in her marital home at in the South Salmara district. The circumstances in which the petitioner married her husband is stated to be unacceptable to her family members. And accordingly, an apprehension is raised that if the petitioner returns back to appear in her final examination, final or intermediate,
Finally,
in her final LLB, in her final examination for the LLB from Dispur Law College, there may be a serious threat to her by from persons who were inimical to her marriage. Accordingly, this writ petition is instituted that for a direction that the petitioner number 1 be allowed to sit in the LLB final examination from any of the centers from the South Salmara Mankachar district, so as to avoid the possible untoward situation of facing difficult situation if she comes back to appear in the examination from Dispur Law College. Mr. P.J. Phukan, learned counsel for the respondents in the Guwahati University, after referring to all the relevant rules and regulations that are presently in force, makes a submission that under the existing rules and regulations, it is not permissible for a student who is not permissible for a student of one law college to appear in their final law examination from another law college. And therefore, there will be a technical inconvenience to accept the prayer of the petitioner. We respect the submission of Mr. P.J. Phukan and do not want to impose it on the respondents in the Guwahati University to do something which is impermissible under the rules and regulation. But however, it has also been pointed out that the Vice Chancellor of the University under Rule 8B of the Guwahati University Act has a discretionary power to 8B to discretionary power under Rule 8B1 has the discretionary power 8B1 bracket 4, 8B bracket 1 bracket 4 to pass any order in any emergency which in the opinion of the Vice Chancellor requires an immediate action to be taken. And in such event, the Vice Chancellor may take any such action as he deems necessary, and thereupon at the earliest opportunity report his action to the officer, authority or other body who or which in ordinary course would have dealt with the matter. Reference is also made to the provisions of Section 23 of the Assam General Clauses Act. Of the Assam General Clauses Act, which is perimeter to Section 21 of the Central General Clauses Act, which provides that wherever by any act, A capital, any act, a power to make or issue notifications, orders, schemes, rules, forms, or bylaws is conferred, then that power also includes a power exercisable in like manner and subject to the like sanction and condition, comma, if any, to add to, comma, amend, comma, vary or rescind any notification, order, scheme, rules, forms, or bylaws. By referring to Section 23 of the Assam General Clauses Act, a submission is made that even though the rules and regulations presently in force do not permit a student to appear in the final year law examination from any other college other than the college where the student had undertaken the course, comma, but Section 23 of the General Clauses Act also provides a power to the authorities to deviate from the existing rules and regulation if the peculiar facts and circumstance of a particular matter may require it to be done. 23(1)(n), Section 23 are extracted as below. As a reading of the powers of the Vice Chancellor of the Guwahati University under Section 8, bracket 8, bracket B, bracket 1, bracket 4. Last sentence too. Comma, conjointly read with Section 23 of the Assam General Clauses Act, comma, both provisions which are extracted as above, comma, we are of the view that if it's a situation in the nature of an emergency or an extreme situation where there is no other remedy available, the petitioner may submit a representation to the Vice Chancellor of the Guwahati University stating in detail all the attending and relevant facts pertaining to the matter, also showing that, also providing materials that there may be a serious threat to the safety of the petitioner if she goes back to appear in the final law examination from the Dispur Law College. And in the event of such representation being made and upon the Vice Chancellor, if satisfied with the materials that may be produced, may pass any reasoned order as may be advised in exercise of the power under 8(1) Guwahati University Act, read with Section 23 of the General Clauses Act. We request the Vice Chancellor to pass the reasoned order within a period of 7 days from the date on which the petitioner may submit a representation.
Just point out, Lordship, that in the South Salmar district, Lordship, there is no law college. It is
Sorry?
in the South Salmar district. There is
It is stated that the South Salmara Mankachar district may not have a law college. If it is so, the Vice Chancellor may examine as to which other law college would be suitable for the purpose. And accordingly, if so advised, may pass the order.
Item 3.
Mr. Phukon, take it a little later. We'll be quoting that section.
Well, kindly pass over the matter for the time being.
Obliged. Item 4.
While this matter is to compassionate appointment.
DLC,
DLC has rejected without assigning any
page
reason.
number,
Page 19, my lord.
what is this name? of
Serial
the-
number 43.
Shyama Sinha. Where is Shyama Sinha name?
Serial number 43, my lord, at the bottom, my lord.
Yes, Mr. Pegu.
Lordship, the matter is heard by
Majority, sorry.
lectures and delay, your lordship, at page 18, your lordship. All the reasonings are given, your lordship, and the matter was rejected in the year 2009 only. So it is completely.
Where
heard
is
by lectures
the
and delay.
provision in the order that an inter-se financial comparison was made?
Yes, your lordship.
Where?
in the page 18, your lordship.
We have not seen it. We have read page 18, but it is not there.
After taking into account the liabilities,
That
financial
is
position.
a general statement. Do you expect me to pass an order? Heard Mr. Deudi and Mr. After taking into consideration, I allow the petitioner. Will you be happy with that order? Or I reject the petition? I'll use the expression, after taking into account all the aspects, I pass this order. Will it be acceptable?
My,
Okay, use file an affidavit from today onwards, our work will be easy. We'll start, based on the view of the government of Assam, we propose to dispose of all petitions in this manner. One line.
also the duty of the.
Don't you think administrative order should reflect the reason? See, your officers are giving us the opportunity, we are making the best of it. And they are the beneficiary.
The grounds might be in their record, your lordship, in the operation.
And then that is not good enough. Paragraph 20, but Mahinder Singh Gill, the order should reflect the reason, not supporting material. Supporting material you can bring in by form of an affidavit. Supreme Court rejected that procedure. Go back. What to do? Ask your officers to work a little more. Make the orders foolproof so that no one can interfere with them. More and more these kind of orders, more and more will also send it back. You're giving advantage to somebody else.
Lordship, after taking this, since the statement is that after taking into account.
Yes, so we'll also dispose of, say, after taking into account all the aspects, we pass this order. And we'll also reflect in our order why we do so. If your order can be justified, our order can also be justified on the same reason. Go back to the basics of administrative law. Find out how an administrative order is to be passed. You train up your officers.
My submission would be that the matter is heard by Luscious and written. Although.
Sorry, no, we'll record your submission. Not that we are ignoring your submission. We'll record it. Heard MSSB Chaudhary, Learned Counsel for Petitioner, also heard Mr. B. Deuri, you are junior advocate additional.
Junior.
Learned junior advocate for the Deputy Commissioner Karimganj, Mr. E. Fukan for the respondents in the Elementary Education Department of the Government of Assam. The father of the petitioner, late Haripada Sinha, who was an assistant teacher in the 391 number Patiala LP school in the Karimganj district, died in harness on 18/8/2007. And on his death, the petitioner made an application for compassionate appointment on 17/3/2008. It is stated that the said application was given its consideration in the meeting of the DLC held on 9/7/2009. DLC of Karimganj, wherein where is that line taking into all consideration?
Lordship, the second para, in terms of.
Wherein it is provided as extracted. It is provided as extracted. On a question being raised as to where is the depiction of the inter se financial comparison of the respective candidates in the resolution of the DLC dated 9/7/2009, Mr. B. Deory, learned judicial advocate, points out to the aforementioned paragraph and points out that in the paragraph, the DLC had stated that the claims of the most needy candidates as noted therein were recommended for appointment on compassionate ground after taking into account the liabilities, financial position, size of the family of the claimant, as well as availability of posts during the relevant calendar year. Full stop. The aforementioned portion of the resolution of the resolution committee is a requirement of law as laid down in Achyut Ranjan and Fazilun by this court. But it does not reflect that the exercise that is required to have been done was also undertaken, other than making a claim that it was done so. Any administrative order divorce a reason would be unsustainable in law. Merely a statement that what was required under the law had been done is not sufficient until and unless more reasoned order is passed, which would enable a higher authority to examine as to whether the exercise was undertaken in the required manner under the law. Having provided as such, all that is provided, as such, by the resolution, the name of the selected candidates were stated and the names of the rejected candidates were also stated. Such an order will not enable the court under judicial review to examine as to whether the authorities had actually undertaken the required exercise under the law, and in doing so, whether the correct procedure was followed or not. From such point of view, Mr. B. Deory, learned judicial advocate, also makes a submission that the supporting reasons can subsequently be provided by the authorities. Any such subsequent reason to justify the resolution of the DLC would be impermissible under the law in view of the proposition laid down by the Honorable Supreme Court in para 21 of pronouncement in Mahinder Singh Gill versus Election Commission and others, wherein it is stated that the reason to justify an administrative order cannot be subsequently substituted in the form of an affidavit in a course of a court proceeding. From such point of view, we are unable to accept the submission that the reason would now be substituted by the authorities by means of bringing additional material or through an affidavit. We are also of the view that as the aberration of the required procedure of passing an administrative order is writ large in the order itself, we are of the view that no further purpose would be served by issuing notice, inasmuch as the plain reading of the order as extracted or do not reflect the reason as is required to be made by the administrative authority while passing an administrative order. Accordingly, the rejection of petition is set aside, remanded back to the DLC for a fresh consideration under the law.
Lordship, may I submit, please allow to submit one point. Your Lordship.
Please.
Page 19, Your Lordship. It is page, the complete DLC has not been annexed to because
Even if it is not.
continuation might, that continuation of the said DLC may hold the purpose or the reasons.
Do you,
Maybe because
do
he
you,
has not annexed that.
Mr.
Yes,
Deory,
yes.
do you seriously believe that after taking a decision, the reason will be subsequently following? After the decision is reflected, do you seriously feel that the reason of the decision will be subsequently available? First I line the right, writ petition dismissed, and then go on giving reason why. Do we do that? It is not so. If it is so, we are not signing the order for one day, bring it to us.
Definitely,
We'll record
definitely,
it.
definitely.
But if you cannot, a cost of 1,000.
Lordship, it is my duty, your lordship.
Do your duty. Yes. Will not sign it till tomorrow.
Yes. Anything exists on.
Nothing is there, Mr. Deori. We have read, till now we must have read thousands of these kind of orders. Nowhere we found it.
Item 5,
Mr. Deori, why can't you instruct your authorities to just write one tabular form that these are the 12 applicants before us, these are the financial information about them. We find that so and so is the financially worst off, we accordingly recommend. Which authority will interfere with that order? Tell me. You deliberately don't do it because actually our apprehension is you don't actually carry out that exercise. Recommendation is made on the basis of some other extraneous factors. So you don't put the reason because you cannot put the reason. Because the moment you put the reason, that recommendation cannot be made. That's the only reason, nothing else.
They have made that statement.
In one matter, we understand, but in hundreds of matters, same thing cannot take place otherwise. Yes, Mr. Borgohain.
Lordship. The petitioner name was recommended for under convention appointment.
Which page?
In page number 27, his name has been reflected in third. Arunima Chetia, Pallab and petitioner name is Bidut Kaur. Page number 27.
27. Where is the name of the petitioner?
Bidut Kaur. Third name.
27.
Page number 27.
Bidut Kaur.
Bidut Kaur. But it was never placed before SLC, Lordship.
Go and place it. But again, same thing, no reason, nothing. The man you give also no reason, the man you reject also no reason. I heard Mr. E.V.S. Borgohain and Council petitioners. Maybe the same thing.
Bidut Kaur.
Yeah, lordship, let me obtain the inspection whether it has been placed in the SLC or not.
No, place it. If already placed, inform him.
Yes, sir.
Why you wait for
Yes,
that?
yes,
One more day of listing,
yes, yes.
unnecessary.
yes, definitely.
Mhm. Who's the name, father? Name of the father?
Padmeswar Kaur.
Where have you stated?
In his first title in page 4.
Cost title is not supported by affidavit.
Lordship may kindly. I annex also death certificate, Lordship, page 20.
Annexures are also not supported by affidavit. So while writing, you have forgotten who was the father. If you don't tell the name of the father when he died, where he worked, how can they examine your case? Because your right flows through your father,
Yes,
not through on your own.
yes.
So unless you give this information, how do you expect us to direct them to examine your case?
You can put on order dated 6/11/23 or okay. Order dated 6/11/23.
Incorrect annexures have been appended. They must have corrected it by now.
All is corrected.
No information is available in the writ petition. other than in the cause title or to be extracted from some annexure as to who is the father of the petitioner, where he worked, when he died, so as to examine the legal right of the petitioner for a compassionate appointment. Petitioner may provide the information through an additional affidavit.
Item 6.
Yes, Mr. Bhuiya.
My lord, covered by my lordship's order, my lord,
Which
that representation matter, at page 87 and 90 is similar.
87.
My lord, may take up page 19.
Today item.
Item number 1 has been disposed of.
Same one.
My lord.
Same. Only the names.
Item number 1, exactly same order.
Fine.
Don't write all these things. আৰু খালি সেইটোত এটা লিখিব Mr. B. Chaudhary and Mr. A. Phukan also agrees that the matter involved is covered by the state order. Headline to that add কৰি দিম। এতিয়া খালি হেৰি দিব দে গণেশ Phukan, not A. Phukan.
7.
The cancellation order, Lordship.
Cancellation order.
Cancellation of the service of the petitioner.
Which page?
Page meter, page 30.
30.
Three.
Where is the High Court order?
Lordship, page 23 and relevant portion, Lordship, 27. And last part, Lordship, below. In the event of filing such representation agreed by the.
In the event of finding us by the petitioner, who is the petitioner?
Petitioner is there.
Somebody else.
Some. His name is not recommended by the.
And where you were respondent in that,
Respondent, I am neither respondent nor. I am the-
you are not a respondent in that
I
matter.
am not respondent, and-
Heard Mr. D. Nath, Land Counsel for the petitioner. Also heard Mr. Ganesh Pegu, Land Counsel for the respondents in the Elementary Education Department of the Government of Assam. The petitioner Afzalur Rahman claims to have been appointed as an assistant teacher science in the Durgapur Para ME Madrasa as per the order of the school managing committee of 26/8/2001. And that since the date of his appointment, he has been working in the school. Where is the order of provincialization?
Page 20.
Page
20.
20. The services of the petitioner was provincialized by the order dated 5/2/2021 of the Director of Elementary Education Assam under the Act of 2017 as a tutor in science.
Lordship, not in your science, is the assistant teacher's tutor.
There is nothing called in a ME school, there is no assistant teacher tutor.
But here not mentioned, not even in science or.
No. The tutors will receive and only tutor science will receive fixed salary. How much did you get? What was the amount paid to the petitioner?
Lordship, in salary statement, I have given the.
It was paid 10,800 or 11,700.
10,800.
He was paid 10,800. Anyway, as a tutor. Another teacher of the school, namely Sahanur Mondol, challenged the provincialization of two other teachers, namely Dilbar Hussain Sheikh and Abdul Qadir Mia. In WPC 2064-2021, wherein the court had passed an order, the relevant portion of which is extracted is below, is 27 or second last or last paragraph to quote Koridiwa. A reading of the said order of the court makes it discernible that the respondents number 8 and 9 in the said writ petition, namely Delaware and so, are also to be given a hearing while giving a consideration to representation of the writ petitioner therein, namely namely Sahanur Mandal. Consequent thereof, the order dated 1/11/2023 had been passed by the Director of Elementary Education Assam, by which it is provided that in compliance of the court's order dated 23/6/2022 in WBC 2064-2021, and also based upon the report of hearing on 29/5/2023 in respect of the parties involved in WPC 2064-2021, and also as per the decision of the SLC dated 12/12/2022, the order of provincialization in favor of the present petitioner, Afzalur Rahman, was cancelled with immediate effect. A reading of the order itself makes it discernible that the petitioner was not given an effective opportunity of hearing, inasmuch as he was neither a respondent in the WPC 2064-2021. Further, the order of cancellation or provincialization of the petitioner by referring to the order dated 23/6/2022 of this court in WBC 2064-2021 also appears to be an attempt to overreach the order of the court, inasmuch as all that the court had provided is that the two respondents in the said writ petition, namely Delaware and Omuk, are to be given a hearing, meaning thereby the director would examine the claim of the writ petitioner in the said writ petition, namely Sahanur, vis-a-vis Delaware and Omuk. And there was no scope for the director, without initiating any further process, to interfere with the provincialization of the petitioner Afzalur Rahman. In view of the prima facie case made out, the order dated 1/11/2023 cancelling the provincialization of the petitioner Afzalur Rahman shall remain state until further orders. Staying of the order shall not preclude the director to pass any effective order pursuant to the order dated 23/6/2022 in WBC 2064-2021, wherein only 3 parties are involved, that is the writ petitioner therein Sahanur, and the respondents number 9 and 8 therein, 9 and 10 therein, namely Omuk and Omuk. Between those 3, you do whatever you do. Without following procedure, don't cancel the other man.
That's one here, I have mistake in.
Correct it.
Item 8.
8 weeks ago, you applied.
Matter part is to compassionate appointment.
DLC,
DLC not placement. Page
not
13 is
placed.
my application.
Pass the same order. Give the particulars.
Lordship, from perusal of page 12, your lordship, with you on your lordship. Page 12, where the next of kin certificate has been annexed. It seems that the mother was 37 years at that moment. So what I pray is that the concept of die in harness, your lordship. So it is absent in the state application.
Sorry.
Because 37 years she could have applied. Now after 13 years, the petitioner has been that means in the year other expired in the year 2011. They have made the application in the year
The Supreme
2009.
Court has considered this aspect in Khadim. Follow Khadim and do whatever is required. Your objection had been dealt with by the Supreme Court in that Khadim judgment. Follow Khadim and do it. If he is entitled, give him. Not entitled, reject it. But that doesn't mean you'll throw away the application.
It cannot be a
Pass.
matter of choice. That is what-
Sorry.
it cannot be a matter of choice.
That
Since
is,
2000
Supreme Court has rejected that argument, Mr. Deori. Please read the judgment of the Supreme Court. Yeah, an objection is raised by Mr. B. Deori during an advocate that when the deceased died, the mother was about 37-year-old, and whereas this is an application by the son or daughter, son, after attaining majority, and that too upon lapse of 13 years. The state aspect had been dealt with by the Honorable Supreme Court in Khadim, wherein a proposition had been laid down. The respondents in the DLC may take note of the proposition laid down by the Supreme Khadim and pass their order. If we had queried for the baki in it.
My lord, the application was made on 2019, so after 8 years.
It is his submission. Then we'll issue notice, we'll hear you, you file affidavit, you object to that.
No.
Item 9 for admission.
My electronic instruction from the chief secretary is that he has received the reports from all the deceased, and he is holding a meeting tomorrow. Because in between there are.
I understand.
So that will be
Say-
for 3 days time,
We'll list it on Friday.
Friday or
Uh,
Monday. Friday or Monday.
On the prayer of Mr. B.J. Taldal and Senate Council for the respondents list on in view of the statement made that the Chief Secretary Gandhi Assam has called for report from all the deputy commissioners, and for the purpose a meeting is scheduled to be held on Ahakali date. Put it on the legislative side. I think whatever you do.
Yes.
Hmm,
So as soon as to go from there. We'll see. It's coming on Friday or Monday.
Monday,
Cited.
but not later than Monday. Monday you do it finally.
Monday.
Otherwise, we are not going to adjourn it anymore.
Item 11.
Yes, madam. Item 11, what is this? Yes, Mr. Das, what did you get?
I have gone through the records below and as well as the initial fee statement of the other stenographer, as well as the employees, other employees of the High Court. But what I found is that all the fixations are made with effect from 1/4/2016. The revision of pay has been made with effect from 1/4/2016. My lord, although I have been instructed to file an additional affidavit, my lord, even then I am just placing the IPS of the officers.
IPS means?
Initial pay statement. This is the pay fixation done under the ROP rule 2017.
No, we don't want all this. We are taking up at 2 o'clock.
Okay.
Which register is in charge of this? Let him remain present.
Right.
Make a categorical statement that none of the similarly situated employees had been given the pay benefit as claimed the petitioner, and all of them given same treatment as the petitioner. We'll close this petition. But if the statement is wrong, there will be contempt. Definite materials have been produced that the statements are wrong. Why are the authorities trying to defend it? Who is instructing you? Please bring that man who is instructing you.
My lord, last time.
That clerk or some
One Mr. Pathak is there.
Pathak. What is his designation of that Pathak?
I'm sorry, my lord, I'll have to ask, my lord. I'll just.
We don't want to follow instructions of the clerks, dealing
my lord.
clerks.
But apart from, my lord, they are saying, my lord.
Because this dealing clerk is putting the registrar onto a jeopardy.
My lord, apart from what they say, my lord, I myself also cross-checked the record. So that's why these are placed before your lordships, my lord.
What is placed here?
These are initial pay statements. These are the revision, how the revision was done with effect from 1/4/2016 under the ROP rule.
Hmm.
Petitioner's case.
So
was that he got-
everybody for the purpose of basic pay, you are taking PSP, adding the PSP,
Yes, my lord. there is
and
no-
then the fitment is made.
Yes,
Why for this man another approach was followed?
No,
This, Mr. Das, in spite of all your efforts, we
I have-
feel that the attempt is to manipulate rather than be fair. Slowly, we are coming to that conclusion. See, this man, Horinath Pal, clause 7, basic pay in the pre-reverse structure, 25940. Okay, that is the total basic pay. It comprises of 18,790 pay band, 5900 grade pay, 1250 TSP.
PSP.
Total amount is 49090.
My lord.
So 49090 was the figure for the purpose of fitment.
Yes, my lord.
Okay. Please take out that page 44. Somebody is trying to play a game, Mr.
Hello.
Das. We are sorry to tell you.
Lord,
And either, I don't know about you, Mr. Das, as a counsel, but
Lord, I am duty bound, whatever I have found from the records, I have placed before
no,
your
you have
lordship.
placed it, but so now you see,
Page 37, my lord, will kindly
we're
see.
not going to fetch you, we are going to page 40.
No, compare with this
No,
record,
sorry.
my lord.
Don't do all these things.
I'm sorry.
A mischief had been done, we are trying to find out the
My
correct
lord.
thing. Now, 49090 pay band, 49090 is corresponding, no, not 490, 25940 is serial number 14. Okay. Come to page 40,
Yes,
serial number 14. Serial number 14 revised pay is 63640. So come to clause 11 of that Horinath Pal. It is 63640. Okay. So now, if this man on the pre-revised in grade 1, he was getting 1200 plus 5900 plus 1250, it comes to 19,150. 19,150 will be corresponding to 47320. But you have made him 4330.
lordship is referring to Horinath Pal, my lord, in the documents that.
The
I-
document you have given, we have not, no
I-
one
I-
created this
I was
document.
cross-checking, my lord. Lordship will kindly, my lord, I don't have the another copy, my lord. I beg your pardon, my lord.
Look at it, just give it.
Yes,
So let us close this matter. 7, this one. And revise this. This one. And we are slowly feeling that contempt notice should be issued against this clerk who is misleading all the time. Should we do it? For the last 10, 11 dates, this man is trying to mislead the court. Give the name, we want to draw contempt against him. Mandu. Ask him to come, who is instructing you all the time, giving you wrong information. And don't use those complicated mathematical equations. Use the simplest of the one, which is applicable.
Lord, if I may place what I have understood from here, my lord.
We don't want what you understood. We
This is
see
as per
what,
the rules, my lord.
no, we see what we have seen
I understand, my lord. Lordship is
and you
complete-
follow it. That's all.
My lord,
And tell the name of the man, we are drawing contempt
Lordship will do, my lord, but perhaps
after some time.
no,
Okay.
before that, my lord, I just like to, my lord, place my.
Why
understanding-
will you say something incorrect?
No, I'm
We are
just-
going, Mr. Das, we are going to question you and we are, if you continue with this playing the game all the time, we may have to be more strict with everything.
my lord, I
We
apologize, my lord.
are,
I'm not.
we are seriously expressing some words, and if you want a quarrel to be started, begin the, let us see.
my lord, not
Let
at
us see
all.
where it ends.
My lord, I'm here to assist your
Please
lordship.
do
my
it
lord.
properly and earnestly.
So that is why I'm trying to, my lord, paste, if column 7 lordship has referred to 25,940. This was the pre-revised pay.
Mr. Das, what will be the equivalent column 7 of this employee before us?
This 25,940 lordship has referred to, it will be placed in the fitment table of that particular person, and 49,090 is the revised pay.
Revised pay band.
No, my lord,
Mr.
pay in the
Das,
pay band. It says pay in the pay band.
then read column 11. One
Yes,
is this
I'm
mark.
coming to that, my lord. So 49,090 we got after ROP. And-
Contempt notice, who is the name of the clerk? Please bring him. Issue contempt notice on so and so.
Lordship will take up at 2, my lord.
Yes, contempt, we are taking along with the contempt.
Lordship
Ask him
will-
to come.
I'll ask him, my lord. Lordship will take up at.
Enough of this playing the fool, Mr. Das. Enough of it. You have done it for 10, 15 days now. Along with your employees. A simple equation we are telling you. Mind you, write it down what we are saying. Please write it down because you are always have a habit of manipulating and escaping. This man, before the pre-revised was given effect on 17th of March 2017, was in grade 1. He was getting a pay band of 12,000, grade pay of 5,900, plus PSP of 1,250. Total comes to 19,150. Okay. 19,150 is corresponding to serial number 4 of the page 40. Corresponding revised pay is 47,000 something. You are putting him in 43,330, which is corresponding to serial number 1. There his basic pay is 17,900, meaning by you are not including PSP in the basic pay. You are saying that that is the rule of calculation. We asked you, are you following it to each and every employee of the High Court? You said yes. Then we asked you to produce the pay slip in respect of some other High Court employee. You have produced one, Harinath Paul, today. Harinath Paul, pay band plus grade pay plus PSP, 3 components comprising of the basic pay came to rupees 25,000 odd. 25,000 odd is corresponding to serial number 11 of the page 40 fitment table. Corresponding figure is 63,000 something. And column 11 shows Harinath is paid 63,000. And you are trying to take out what expression to use against these people, I don't know. You are trying to again make us understand that he is giving something less. How can you disbelieve the printed word before us and accept a oral submission? Please come to terms. If somebody is entitled, give it. If he is not entitled, don't give it. But don't try to create all this.
Now, this 63,640, this is his revised pay 1/4/2016. Same thing has been done in respect of petitioner also. Page 37, my lord will see. Page 37.
Mr. Das,
Same calculation.
Mr. Das, are you seriously arguing? We explained you this thing on the last date.
My lord.
And
will
you have a
take up
very bad habit of starting the same confusion again and again and every date of hearing. I think Madam Chaudhary, B. Chaudhary was present on that day. Madam Bhumika Chaudhary. She was present on the same day, I remember. Same argument, same thing. When you analyze and tell you that it is wrong, you accept it, go back, fix that next day again, you start from the same one.
Lordship's query.
I think,
I
have you heard the
understand.
word enough is enough?
I
Enough
understand.
is
Milord.
enough.
Your lordship's query was that. Milord, different
Mr.
standards should have-
Mr. Das,
Lordship.
enough of your arguments. Good, logical, reasonable argument. We are ready to hear you for days together.
My-
Absurd things, we are, sorry. It has to come to an end.
My last request will be before your lordship would be to compare this Horinath Paul's Milord IPS.
Mr.
with
Das,
case 37.
Mr. D.H. Das, we are repeating you for the upteenth time.
I'm sorry. I beg your pardon.
This man, only difference is he got promotion from grade 2 to grade 1 after 1/1/2016.
2 million.
Revision of pay was adopted by the authorities on 17th March 2016 with retrospective effect from 1/1/2016.
1 year.
Okay. Now, you have given him the proper benefit in grade 2. But correspondingly, when you calculate after promotion to grade 1 from 1/1/2017 or something, you don't do it. There you take a cockeyed formula, something tangential, and arrive at something different. This is where illegality is done, and we have pointed out, I don't know how many times till now.
Milord,
But-
this query I made before them also, Milord.
I
What
am,
they said, I'm just placing.
we
what
are
they
not
said.
interested in what they say, because Mr. Das, they are telling the absurd for the last 10 days.
I appreciate, Milord.
Call that man,
Milord, what they say is that.
call that man, call the Mr. Day.
Uh,
Yes, we are drawing a contempt. Call him. Next item.
Milord, at 2, my lord. we-
No, right now. Call him. He is here only in the office. Why will he mislead the court every time?
They say they follow, Milord,
No.
Rule 11.
Let him follow a 211. We are drawing a contempt. No, we are giving all the reason why we are drawing a contempt. Yes, let's see what happens.
Item 12.
There's enough of everything, Mr. Das. When politely everything is explained repeatedly again and again on every date, there's nothing called perseverance. There's nothing called adamancy in a court of law. We are sorry to express these expressions. Call that man right now.
My-
Whoever is instructing you all these things.
No.
And tell me one logical thing. Suppose with retrospective effect, you are giving the benefit. If the man is not promoted, he is in the same cadre, you'll give it as it is, the way it should be given.
Yes.
But if the man is promoted in between that retrospective date and the date of actual effect, for the unpromoted post, you'll give him the benefit, but after promotion, you'll adopt a different formula again. Please come back.
Rule 11, Milord, guides that. Lordship will have a look, Milord. Rest I leave it to your lordship, Milord.
Your rule
That is-
11, how many times you have argued till now, and how many
Milord,
times you have pointed out it is not
I would like to
applicable?
read it again if I have not been
Sorry.
able to satisfy, Milord.
No,
If I'm not been.
there
able
is
to
a,
satisfy your lordship,
there
Milord,
is
then I would
a,
like to read it
there is
again.
an aspect called how many times the court will hear the same thing again and again. No court is bound to
But-
hear you for
But what
infinite.
the High Court has done, Milord, High Court has done as per the direction of the Finance Department. The Finance Department.
Now, don't
has
bring in the
provided
finance
this-
department, Mr.
Milord,
Gogoi.
why I'm bringing this? If the Finance Department says that the revision has to be given effective from 17 March.
Yes, Mr. Gogoi, what
2017,
you said to him? To do all these incorrect things? He is making, putting on you now. What
if the
instruction did you
Finance
give him?
Department says that we are.
Where
giving
is
effect from
the,
17 March
where is the
2017,
instruction of
we
the
can
finance?
do it, Milord.
Where is the instruction? Let us see. Let us see the instruction of the finance department.
Because they are giving effect. from
Mr. Das, produce the instruction of the finance department. Have you instructed in this manner?
Well, in fact, only thing is that, my lord, we have.
See, we are fed up of this matter, Mr.
otherwise-
Gogoi.
Yeah, but otherwise, my lord, we have annexed. one
See the
letter.
order sheet, how many times the same thing is repeated again and again and again and again, I don't know how many times.
But my lord, the calculation has been given otherwise by the finance also in annexure A of the affidavit filed by respondent number.
Page number.
My lord, it is. Increment placement.
So that means for giving effect to revision of pay, we understand.
Lord.
If a man is not promoted, remains in the same cadre, he'll get the benefit. But once he is promoted, after getting promotion, he'll get some other benefit, something less.
So here, my lord.
Is it acceptable in any logical presentation?
No, that part I understand, my lord. In fact, my lord.
So what this man would have done is, don't promote me for till the pay is revised. Then promote me after the pay is revised.
No, in the, my lord, in the promoted post also, it has been revised, but the calculation is there in page, my lord, 7. 11th of June 2021.
71.
70.
71 internet page.
What calculation have been done? See, a simple matter of few hundred rupees. We are fighting it tooth and nail out of nothing. If you are not giving it to anybody, we are not expressing anything. If that is the formula, adopt it. No one is questioning you. But you'll give it to everybody except a few people and try to defend it.
So, my lord, they were supposed to place, my lord, whether similarly situated person that of the.
That has already been placed. That Harinath Paul already placed. We are taking note of one at least. Just look at it. Page number?
Page number 71.
71 is not there. Must be some other page.
Run page. Which my learned friend is referring.
आरोपी rules कौन सा हूँ?
In case of any promotion, my lord, which has come up on 1st of April or after 1st of April 2016. So that their calculation will be different, my lord, not. Lordship will see, my lord, in rule number 11. In case of promotion from one post to higher post on or after first day of April 2016, the fixation of pay of a government employee.
Just a minute. Roll number?
Rule number 11.
11. What is rule 11?
It says, my lord, fixation of pay on promotion on or after 1st of April 2016. Here in the case of the petitioner, he was promoted in January
Just a minute.
2017. He will, my lord, cover.
What is it? One increment equal to 3% of the sum of the existing pre-promotion pay.
So my lordship may kindly see now page 71. Here, my lord, after the, my lord, making the calculation in the promotional post, it was found, my lord, after the chart, the amount arrived. at
Just a minute. Yeah, what is the pay of a grade one? What is the minimum pay of a grade one?
It's not 30,000.
No, minimum pay of a grade one. Suppose this man would have entered grade one without any promotion, what would have been the pay?
It is my lord 44,550.
No, this is 44. You are saying from something else. Forget about those figures. Suppose this man would have been directly recruited as grade one on the day of his promotion. What would have been
Double four.
No. I mean the pay band and grade pay and everything.
It will be, my lord, the minimum will be 30,000 plus. grade pay of-
30,000 from where do you get it?
No, extra pay, my lord, 30,000 to 1 lakh.
No, from where do you get it? For this, you are calculating because of this promotion business.
Lordship.
Suppose I ask you, what would have been the pay of this man had it been directly recruited?
Lordship.
What?
Yeah.
Suppose this man, on the day of the promotion,
I understand.
it would have been a direct recruitment,
Lordship.
minus this promotion aspect. What would have been his pay?
Yes, it will have to be there, but otherwise in the.
Sorry?
No, in respect of other departments, it is there in our opinion. Since High Court, my lord, the employees of the High Court directly doesn't come, my lord.
No, there was
So they
something,
will have
something has
adopt,
to be
yes,
there.
They will have to adopt a
So-
particular structure.
Suppose X would have been directly recruited to that grade one post.
Sure.
What would have been his pay band, grade pay plus PSP?
Then it will be, my
Mm,
lord, this
so- Can you give any interpretation to any rule which will say that after promotion, his pay will be lower than what would have been had it been a direct recruitment? Definitely no.
No.
A man from grade 2 to grade 1 is promoted, his pay will be less than a man who would have been equivalently directly recruited to the same post. It is never conceivable.
No, that's why it was enhanced, madam. In the page 71, Lordship will see after the chart. After the chart, the amount arrived at is found to be less than the minimum of the pay scale, pay sum of the pay in payment number so and so. That is rupees 44,550. As such, the pay of Sri Hasnin Alam is to be fixed at 44,550. On 23/1/2017, that is the date of his promotion, with the date of next increment on 1/7/2017. And in the chart, the amount that was arrived after my lord calculating as per my lord rule 11, it was 43,950. So it was NNO. It was lower than the my lord actual pay of the grade 1 pool.
What kind of a rule is this? ROP rules? It's an executive decision, I think.
No, it's a
It's not 307 rule. It's an executive decision.
no. It's a
Mhm. After careful consideration of the report of the so-and-so, government has accepted the recommendations of 7 pay commission with modification as may and pleased to decide as follows. It's a decision. It's an administrative decision.
no, the notification, my lord, 17th of March 2017.
It's
It
an
says,
administrative
in
decision.
the exercise of powers conferred by the provision of Article 309 of the
Where
Constitution of India,
where have you stated?
it's there in the notification, man.
No, the one I am reading, it is not there.
Well, if Lordship is going by this.
No, I am going by the
particular-
Assam Gazette.
Yes, Assam Gazette, my lord, it's 17th of March 2017.
Where is that line?
At the
309?
top, my lord. In the exercise of powers conferred by the provisions of Article.
No, that line I am not getting.
Lordship may. I'm having-
Then what is this then?
No, well, it's there. This is not the one. But you will find it at page 305 of this contract.
Mhm.
It's there. Three zero five.
What is the difference between the first one and the second one?
Well, by this notification, the resolution to ensure. were
No,
adopted.
no, both are notification.
Yes.
Okay. One is the Government of Assam Finance Department
Yes, sir.
Constituted so and so, so and so, so and so. The commission submitted a report, Government of Assam considered committee under so and so. After careful consideration of the report, the government has accepted any other motivated necessary as decide as follows. This is notification FPC 120 part 1.
Right.
Then next one is FPC something 217 part 2. Both are dated 17 March.
After accepting, my lord, this particular rule has been now carried out. Incorporating, my lord, whatever recommendations was finally accepted by the government.
Constitution concern.
This is extended. This will definitely.
Madam Ghosh, this lesser salary is paid all along or up to 17 March?
After, because prior to that on.
No, after 17 March 2017, what this man is getting?
He is getting what is there. in-
No, he is getting the what you are claiming or what is
He's getting less than what I'm claiming.
even after 17 March.
Yeah, because still, when I was promoted on 23rd of January 2017, my basic was 17, my basic was Lordship 17,900. That is
No,
12,000 plus
that is
4,000.
that is as on which date?
As on prior to revision. Prior to revision, I got the correct basic. My basic was 12,000 plus 5,900 plus 1,250. Prior to that, and I have a salary slip also, Lordship, which I can place before Lordship. My salary
So,
was on
Gogoi,
May
this appears to be
2017.
it appears to be an inconsistency.
So,
In
my lord, it's
2017.
not the case of the petitioner that, my lord, despite the revision which he ought to have got, my lord, he has been given, my lord, lesser pay. His claim is that as on that he is getting higher, but he should get more as per his own calculation.
Definitely.
As per, yeah. So
This
to
is
say
not
that, my
my-
lord, say prior to revision, he was getting higher. After revision, he has been brought down to a lower pay scale. Or
because
that
prior
is not the case, ma'am.
No,
My case
no,
is
no,
not-
just a
may I
minute.
submit?
A man is getting without any revision. On the day you adopt the adopt the revision, he is getting 12,000.
Yes.
5,900
Yes,
plus one is, so he is getting 19 something. That is his basic.
That's-
Okay. Now, to give effect to the revision, you bring in one clause 11. Instead of making the equivalent fitment for the revision, now you read your clause 11.
One says, in case of promotion from one post to higher.
No, this is,
Follow after
no,
first
what
day.
you are saying, I understand what
Yeah.
you are saying.
Kamala C.
Just a
Probably.
minute, just a minute. Now come to that page 312, I think, for your book. So now come to C.
Lordship. In case the promotion from one post to another.
In
involves-
case the promotion from one post to another involves movement from one pay band to a higher pay band, huh?
Lordship.
This is possibly what happened in this case. He has gone to a higher pay band. Then also
Fixation of pay consequent to
fixation of pay conjugate shall be done in the same manner as A and B.
N.
This is where you have although it's a 309 rules, it is your prerogative. This is where you have there is a little bit of aberration. Then you read, however, if the revised pay is so arrived at the consequent to promotion
Comes lower.
becomes lower than the minimum of the higher pay band to which he has been promoted.
Then
This is what has happened. If you follow A and B, the 3% increase what the formula you have adopted, this man after revision will become lower than he'll become lower. So to protect it, however, if the revised pay becomes lower than the minimum of the higher pay band to which he has been promoted, then his pay shall be fixed at the minimum of the higher pay band. So now what you have done, which possibly under service law jurisprudence you cannot do. This man, just listen carefully, and this man is getting 12,5900 plus 1250 basic pay. Comes to 19,150. Then he will be corresponding to serial number 4 of page number 50. Page number 40, I mean. Come to page 40. Okay.
Right.
Because 150 corresponds to serial number 40.
Right.
He will come to 47 something. By one stroke, what you have made, the basic pay that he was already getting, you have brought it down to serial number 1.
Well.
Very well. And then took the equivalent of serial number 1, that is
30,000.
43,300. You have put him in there.
Got
Can you do it?
Sir.
Well, any kind of formula in a revision of pay, all you are entitled to do is to find out equivalent fitments.
Right.
In doing that, can you bring down the basic pay of a person? Yeah, now you have brought the basic pay down.
So far as this particular calculation is concerned, this is applicable to all the grade 1 minor personal secretary in the principalship of this honorable court.
Which one?
This particular minor calculation, that is 30,000,
No,
110.
no, it is not. Take the Harinath Paul. It is different. Only difference is Harinath Paul was a grade 1 all along.
Yes.
From 2016, he had been a grade 1. This man became grade 1
17, January.
January 17. That is the only difference.
My basic prior to this thing was.
So now if you
90,000.
adopt this formula, I think we'll have to declare this formula to be little arbitrary. Because if I understood your formula rightly, if a man is promoted, you are bringing him down to a lower basic pay, which is a fiction that is created.
Right.
This is basically a legal fiction. Understand? It's a legal fiction.
You have to challenge this.
No, you don't have to challenge. We will interpret.
Yes, this is what-
Legal fictions are always available to give a positive benefit. Legal fictions is never available to take away a factual situation which is already existing.
This Harinath Paul Is there a same calculation has been made?
No, not
This-
that. Look at
this
serial
is
number
the-
7 and number 11. Not same, not made.
12,000. Otherwise, the formula has been adopted, same calculation has been made.
Yes, it is not, it is different. We read it. Only thing, what I understood, Mr. Gogoi, of procedure you have adopted till now, the moment this man was promoted in January 2017,
Right.
instead of making the equivalent fitment as per page 40 table, this however entitles you to bring him to the minimum of the higher pay band. Whereas by virtue of fitment, he would have been not at the minimum, but at somewhere in at serial number 4. This will entitle you to bring him to the minimum of the pay band. If I accept this to be correct, you are right. Calculation we are making is right. But a man who is otherwise a little ahead after promotion, he cannot be in revision of pay. In revision of pay, that man cannot be brought back to the minimum of the pay scale.
But my lord, there is no such affidavit, my lord, or on record to state, my lord, with a specific statement that, my lord, after this revision at page 71 that I have placed, my lord, there is, my lord, 44,550. The present petitioner was on, say, my lord, in January 2017, he was enjoying higher pay.
He was enjoying higher.
Yes,
He was enjoying
19,150.
1,150.
19,150.
It is there.
It is there, Lordship. In May, I have received
No,
that.
That is there. It's
the
admitted.
actual pay, my lord.
Actually,
Yes,
that was it.
It's affidavit I have read stated.
No, this I have seen one document. It is there.
Yes, Lordship.
Hmm.
Why did you calculate to be joined?
So, Mr. Gogoi, this, however, provision,
Lordship,
it's a legal fiction. Okay,
my lord.
please read the law of legal fiction. Legal fiction, what is legal fiction? Something which does not exist on fact. Under the law, it is deemed to be existing. Okay, but which does not exist. Say your Provincialization 2011 Act, it's a legal fiction.
Lord.
Although the man is not provincialized, it is deemed that he is provincialized from 1/1/2013. It's a legal fiction. But legal fiction is not applicable to an existing fact. By creating a legal fiction, you cannot take away an existing fact. By this provision, you are taking away an existing fact that this man is in the pay scale of that 12,599,150. Total comes to 19,150 and bring him down to the minimum of the pay scale of the promoted. And had it been so, you should have he should have been getting the minimum of the pay scale before the revision also, but he is not getting. And a legal fiction can never be created to take away an existing fact and substitute a new fact. Legal fiction is always a non-existing fact. By law, it is deemed to be existing. This is where the
Only
fallacy
the
is
case
there.
of the present petition.
Hmm.
Not that in general, my lord, some irregularity. has
In
been
general, we
found.
don't know. We are concerned with only one petitioner. Understood?
My lord.
Please, we'll take up tomorrow again. You apply your mind on this.
But my lord, here, my lord, that statement, my lord, specific statement is not there.
Forget about faces to it. In the fact, it is there,
Yes,
Mr.
I have my salary slip, Lordship, of May 2017. My basic was 12,000 plus
No, what?
It is
5,000.
there, Mr.
But late fee is
5,000.
only 42,000.
Sorry.
net pay is 42,000.
We have to see the basic.
revision.
What was my basic? My basic was
Before
12,000 plus
pre-revision.
5,900 plus 12
We are on basic, Mr.
basic pay.
No, I understand that, madam. What rule 11 says, madam, that please, says
Regarding,
that, madam, if in case, madam, it goes down. Even, madam, on the day, madam, when the petitioner was promoted, prior to revision, madam, his pay was only 42,000. It's not that, madam, after revision, it has gone down. He was enjoying 42,000 in the promotional post.
Hmm.
In the promotional post, in May.
No, in May, yes, in my,
In May.
my
May
basic,
2017,
basic
it's
has
the
to be
net pay is, madam,
clarified.
42,000.
Net pay includes DA and all.
Yes, Lord.
So even then, madam, the promo.
My basic,
DA, forget about the DA for the
yes,
time being.
basic has.
DA
to
will
be
again add to the confusion.
Yes, Lord.
No, I'm not.
Go by the basic.
Basic was 19,150 Lord. 12,000 plus 5,900 plus 1,250.
It can't be, mister.
And that is 17,900 is for the government employees, not for the High Court employees.
The government, while adopting the ROP, or even if you make a rule under, call it to be a rule, actually, this is not a 309 rule. This is basically an administrative decision, how you will implement. Everything is not the 309 rules. By using the expression 309, it doesn't become 309. This is basically, there you cannot, by a deeming provision in the decision, bring down the scale of a person to a lower level and then make the fitment. That will be impermissible. You were relying on only on the principle of legal fiction. Legal fiction is not available. Then tomorrow you can always say that yes, we are revising it. A man who is getting 100 after revision will get 200, but we'll deem that he's getting 50. And after revision, he'll get 120. You cannot do that. You don't have the administrative authority to take this decision. Understood what has happened?
11C otherwise takes care of that.
Here, but 11C is somehow it's highly arbitrary and unsustainable in law. You can never do that. Repeating the example I'm giving, a man is getting rupees 100 before revision. After revision, he should get 200. But there will be a deeming provision that you are not getting 100, but you are getting 50. And after revision, now we'll get 120.
That is otherwise.
You are not empowered to do that. Mr. Das, according to you, you adopted the Rule 11. But that also you can't bring it down. By putting all kind of provisions, you can never bring down to find out the equivalent fitment. You can never bring down this K actually paid to a man. Yes, Mr. Mojumdar. Can you use legal fiction to eradicate an existing fact? I don't think so. Only when there is fact does not exist, you substitute it by a deeming provision. And that becomes a legal fiction as if the fact actually exists. But legal fiction can never be used to take away an existing fact and substitute it a substituted fact. I don't think so.
Hearing this is very interesting. After promotion, he says he's getting less.
This is the mischief in 11. That line, however, and that 11 itself is a mischief.
But it will have to be put in the rule.
That is what state.
So before promotion, if he is according to fitment of what he is actually getting, although retrospective, after promotion also, whatever he was getting after promotion, Equivalent fitment. For that purpose, how can you bring him down his basic pay? Mr. Das may be right, you were saying, huh? Mr. Das, maybe you are right, but that's too arbitrary decision.
I'm in a high court.
Mr. Gogoi, product of financial witchcraft, not witch, W-I-Z. Some financial mastermind in the government must have thought this. No one will realize anything. This is the best way to do it.
After. That's a calculation, wrong calculation.
Possibly the facts are not very carrying with each other.
You can't do it.
She is saying that.
Yeah, whatever she said, we have now gone much further than what somebody said and what not said.
Because this proviso is protecting.
It is protecting.
But that is creating a legal fiction where legal fiction is not available. And these are all administrative
Whether This
decisions.
has been properly applied or not by the HB while calculating.
I don't know.
Because we have-
We'll direct whatever the basic pay this man was getting before promotion, before the revision, apply that same basic pay for a fitment. Whatever is entitled, give it to him. Don't go into all this unnecessary.
But if this protection of C is given, he says female and will not have any grievance.
My basic and this was never my basic. My basic was 19,100 prior to revision.
Didi was so concerned. Yes.
Yes.
And it will also be discriminatory because you are discriminating between an employee who was not promoted during this given period. He was already existing in that higher grade. He'll get something. But if you are promoted in between, he'll be brought down somewhere below. This is the meaning of Rule 11. Read it properly. Read Rule 11 again and again. You'll get that. Because you cannot discriminate between an employee who was promoted in between during the interim period and an employee who was already holding the higher post from before.
No,
Now here this classification is made.
Actually, my lord, what I find is this however part is protecting and giving what she's asking for.
Not protecting, taking away.
Taking you.
My lord, it says, I'll just read it back. If the revised pay so arrived at consequent to the promotion becomes lower than the minimum of the higher pay band, to which
See, if the revised pay so arrived means A and B.
Huh.
What does A and B do?
Yes.
One increment equal to 3% term of the existing pre-promotion pay
Huh.
and grade pay corresponding to the pre shall be computed and rounded off. Okay, what will you give this man in promotion after promotion? He'll add only 3% to his earlier pay.
Yeah.
You'll not give him,
Taking the basic of the
you
earlier.
will not give him the pay he is otherwise entitled in the promoted post. This is number one. And after taking A and B,
Yeah.
if it becomes
Minimum. Less than.
lower than the minimum of the higher pay,
Yeah.
a man never gets pay on promotion on the minimum of the scale. He always gets it on a, in revisional pay, he always gets it on a fitment,
Equivalent.
of whatever he was getting.
Equivalent. to that.
On one hand, you are putting a fitment table. On the other hand, you are taking away the fitment table, number one. And by doing this thing, you have created a legal fiction that this man will now be brought back to a basic of
70.
the minimum.
Earlier. Lower.
And not what is actually there. That means actually he is getting 1890. By this deeming provision, you'll bring him down to 17,900.
Basic.
Basic.
This you cannot do.
Yeah.
And
Because this
and
was-
maybe for the other employees of government of some, it may be applicable, we don't know.
I got
Here,
it.
all the confusion is that PSP
PSP.
is added to the basic.
PSP is added.
So here again, even if I follow this one, Mr. Gogoi, there is a way out of the whole problem. Will not observe anything against the rule. Here also, however, he promotion and work which has been promoted, then it shall be at the minimum of the higher band. Now we will add one word, minimum at the higher band plus the PSP.
Yes, sir.
PSP.
Then what-
Yes, ma'am. This particular.
If I
this
give
for the
this-
state government, there is
Yes.
PSP. It is
So
not-
for state government, you may be right, but not for the High Court employees. So we'll just give an interpretation to 11.
Yes, Lordship.
This higher should be read plus the PSP. Moving to do that,
I come in.
it
for-
comes to serial 4.
Yes.
Okay.
That's
So-
why, madam. Rule so far as the rule part is concerned.
Rule is
No,
for
we'll give
state
an,
government.
we have to give an interpretation on
Yes,
the
Lordship.
facts and circumstance.
Yes.
Otherwise, it will become
I have
redundant.
state government.
He is
And-
fully protected.
Yes.
Tomorrow or today?
I'm a high court employee, not a state government employee.
No doubt.
Lordship will interpret that accordingly.
Mhm.
Possibly my learned
Ah.
also saying that. Correct.
This minimum, in case of High Court employees having PSP, will have to be read minimum
Plus the.
plus the PSP and
Yes.
then make the equivalent fitment. Yes,
Yes.
Mr. Das, I think it will meet all the requirements. You have to leave it first. When, no, not that we are right. After all this analysis, this is the only interpretation that is possible.
But this is the first time this will happen. Earlier, it's never. PSP was never included.
It was not included. So now PSP is making all the, or else if you want, you always have the liberty to take away PSP, that's something different. But as long as it's there, you have to give a meaning to it. You can't just brush aside.
In revision, PSP was never included before revision.
Therefore, we have
PSP is
to,
added.
therefore, we are saying all the provisions will have to be read, whatever is provided plus the PSP. So the expression minimum of the higher pay band, plus the PSP. And then make the equivalent fitment. Wherever he comes, you give him that. I think this is why all this problem is created. Both of you are right in saying that we have applied 11, but when you are applying the 11, you have foregone the PSP component, then made it. And after making it, again, you have added the PSP. Whereas it ought to have been making the fitment along with the PSP, which you have done for the already existing employees, which you have done for the pre-promoted post, but not for the person who were promoted in between.
If it has not been done.
This is followed for all.
We'll direct it to be followed for all.
P5 and PSP added. Not to say
Don't
that
worry,
the
Eric.
person has given promotion, not given promotion. Just like it was there. After division, PSP is added.
11 is only for people who are promoted. See what is 11.
Here, they got the promotion, but otherwise also people who.
You don't like to give a few hundred rupees more. Okay.
It's not, my only endeavor is that things are to be placed before your lordship in a proper manner. And I am here to assist your lordship, nothing. I'm,
Otherwise, it is absurd.
this has never happened.
But-
For the first time that your
but-
lordship is taking up this point.
But whatever is that, it has happened.
Yes,
But for this matter, it has happened. That's a difficulty.
because PSP was never added.
Because
Prior to-
PSP was not there in the earlier revision of pay.
PSP was there. Yes.
No, when it was adopted, it was not there. It came later.
While-
PSP came out 5-6 years back, I think.
Yes, lordship.
It
I have the
has
order.
been given effect of 1/1/2006.
Yes, I have the.
2006.
Yes, yes.
Yes,
but
the
this-
order is.
So
Maybe no one was promoted between the date of giving effect and date of implementing.
There are persons will have different kind of grade one. from
Maybe no one has raised the issue,
That's, true. That's,
but somebody is raising it, he is entitled. Tomorrow, look at it, I think that's the only interpretation.
37. is very-
The expression minimum in that,
yes.
However, to that, you have to also add the PSP and then work out whatever it is.
that is the fact. Whether it can be done or not.
Why it
can
cannot
done.
be
In 37, it's very clear, page 37.
Because these rules are divorce the element of PSP anyway.
Yes.
All ROP rules are divorce the element of PSP.
Yes, sir.
Yes. There is.
And there is a judicial pronouncement to add the PSP, and there are other orders to add the PSP.
Yes.
Add it, you get the answer. Mr. Das is still not very happy. What happened?
They will be convinced. Time. Not always possible.
Oh, you have read, you are relying on 11, we have read 11, we have understood 11, we have interpreted 11, we have found the lacunas of 11. Rule 11. Yeah, only reliance is rule 11. You are right. If you apply rule 11 as it is, you are right. But rule 11 has to be applied in this special category of employees in a little different manner. Tomorrow. If you think of something different, tell us. Only while interpreting rule 11.
I love so many.
Not on any other aspect. Don't bring those same argument again and again. Only rule 11, how you interpret, you tell us. Open only for that purpose.
Understood rule 11, that is sufficient for me. But we have seen it, Milord, has not rule it, Milord, has-
I think if you read rule 11 in a manner you are reading, you may be right. Here it will be, shall be fixed at the minimum of the higher pay band, means minimum of the higher pay band plus the PSP. It has to be read. And moment you do that, he'll come to serial number 4 of page 40.
Provided the PSP that is.
PSP is there, right? Or else
My
you
lord,
take,
this notification at page 33 of the petition issued by the judicial department. Whether, my lord, at the time of revision also, my lord.
it will be applicable. It cannot be one time, there till revision.
Please, 37
There are
is very.
two, my lord, mayors.
No, otherwise, if you give the interpretation you have submitted just now, you will make the entire judicial pronouncement to give PSP redundant. That it is only for a specific period till the P is revised. It's not there.
No.
It's for all token time to
Yes,
come.
I'm saying that. Now, while taking up that figure, my lord, to place it before the, with the fitment table, my lord, whether that PSP will have to be added or, my lord,
It is added for everybody.
no, it says, my lord, in case of other.
It is added, number one. Plus, it is specific. Fitment is on the basis of basic pay. Basic pay is pay band, grade pay plus PSP. The formula is there, page 33. Look at the second paragraph.
Yeah, that's why I'm saying, my lord. Principal seat pay shall be admissible to the officers and staff of the principal seat of Guwahati High Court in addition to the respective pay in the pay band and grade pay for determine.
You are not reading the whole of the line, read the subsequent.
Page 33.
No, for determining. Then the formula is given for determining basic pay. That means basic pay,
Yes.
you have clarified it. Basic pay is equal to pay in the pay band, grade pay plus PSP. You have clarified it.
And 54, page 54 also clarified.
So what we'll do is interpolate page 33 and the expression minimum at the higher pay band of that rule 11, give it a complete meaning. And don't worry, no, not much of financial implication. How many employees are there who were promoted between this period? How many employees were promoted between? Very few, I think.
3, 4.
3,
3 or 4.
my instructor.
But if this, subject to, if this is the thing that is, finally decided, that PSP will be included in the basic pay and revised, then there are 840 employees of the party.
Sorry.
If this is,
No, but that you have already given.
no.
Harinath Pal, read.
Original all things are different.
Don't raise the confusion once again, Mr. Das. Read.
My case also, page 37, Lordship, is very clear. It
Even
was
this man, even
Yes,
this
Lord.
man is given the same benefit before the promotion period, for the
Yes,
unpromoted period. Don't add to the confusion,
Page
Mr. Das.
37.
Pre-revised, my lord. Subject to correction. Pre-revised PSP added, here also PSP added.
Anyway, enough of it.
But we will have a relook.
How many times I look at it, Mr. Das? And how many times I'll explain you? I don't know. Everybody must have lost the count. How many times you're explaining the same thing?
Page 37.
Clause 7, basic pay, that is 25,000. It comprises of 3 elements, 18,000 pay band, 5900 grade pay plus PSP 1250. Okay, this is pre-revised.
Yes.
Revised basic pay 63. 63 in page 40 is an entry equivalent to serial number 11, where the basic pay is 25,950, and that basic pay also includes PSP. End of it. We'll repeat.
Second last line, my lord.
One line will not make a difference. Initial pay. What second last line? Which second last line?
Initial pay.
Hmm?
Revise basic pay and initial pay.
What is wrong with that? Everything is okay. Everything.
49 will not placed in the fitment table again, because that 49 has come after.
Mr. Das, please examine carefully before you're making your submissions.
That 49 has come after revision below. That will not be revised again, placing in the fitment table.
Which element in this world is asking you to revise again? Is anybody asking you to revise again?
Placed in the fitment table 49, then comes 63.
Read carefully clause 7 and 11. Don't read others. Read along with clause 11 of page 40.
It has been later added, my lord. Yes, it has been later added.
Sorry.
Lordship will see, my lord, serial number 10 in this.
No, don't read serial number 10. They have added something unnecessary.
No, it says payment.
Mr. Gogoi, don't read all those. Huh? Read only clause 7. Okay.
My lord, basic pay in the.
Just a minute. Forget about that. Mr. Gogoi, please read clause 7. Read it.
My clause 7 of the ROP.
That Harinath Pal.
Right.
It is here.
No.
I'm reading out slowly for you. Basic pay in the pre-revised.
Lord.
Huh? Sure? Understood?
Lordship.
25,940.
No, my lordship, the line is there, my lord, continues. PB plus DP on
No,
the
no.
date from which revised pay structure is applicable.
Don't read all those things. Basic pay in the pre-revised structure. Okay. Amount is 25,940.
Well,
Breakup is 18,790 pay band, 5,900 grade pay, 1,250 PSP. So this basic also includes the PSP. Now come to page 40. Take off page 40. Twenty-five 940 is equivalent to serial number 11, I think.
No,
Yeah.
14.
Hmm.
It will be 14, lordship.
14, serial number 14.
14. 20.
14.
Next highest.
See the revised pay. 63,640.
well.
Hmm?
Lord.
Now come back to Harinath again. Come back to Harinath again. See serial number 11. 63,640, exactly the same figure. Okay. And you don't have to understand anything beyond that. And how 63,640 is arrived at? That's a breakup. 8, 9, and 10 are the breakups.
Yes.
Breakup is PB 49, grade pay 13, PSP 1250. When you add the three component, it again comes to 63,640. This is what I am trying to tell you. And don't get confused. This is so confusing. Moment you look elsewhere, you'll be more confused.
No, my lord, on 1/4/2016, probably, my lord, that person, my lord, he was already, my lord, grade 1. Not a
He was already
subsequent to
grade
1/4/16.
So now there cannot be a difference between a person already a grade 1, he'll get something different.
The
A
form
person who
is-
became grade 1 after promotion in between will get something less. So this mischief is in reading minimum of the higher pay band in rule 11 will give a meaning to it.
So, my lord, it seems, my lord, the others have been given, he has been deprived. That is finally. Lord.
So whosoever others also not
No,
given
because
like him, they will give it to him, and there will be hardly 3 or 4 men.
And then-
In the entire state, there will be hardly 3 or 4 persons, not more than that. not that it will have a huge impact in your functioning. Otherwise, we'll retain Rule 11 as it is, so that other employees of the government cannot raise this issue.
Tomorrow, my lord, at least may I go to that particular case?
This one,
Yeah.
we'll reject it. We'll quote it and reject it to be incorrect.
At least, my lord. Tomorrow,
That has to be rejected because we are giving a different meaning to Rule 11.
tomorrow, my lord, at least.
Who are the council involved in the other matter? One in camera will take up one matter. Yeah, yes, you can say. No, cannot lucky ball.
I think calling it is not answered.
It will love me if you tell. No, we called him specially to have an interaction with Mr. K. It will adjourn it for no use. We'll say that in the absence that endeavor has failed. Mantu to Hanai, June Dimbuli say. He is also not there. Then we failed. এতিয়া মাতিব নালাগে মানুহকেইটাক অকমান ৰ'ব ক'ব
I know. Yeah.
if necessary we'll rise again and take it up in the camera. Mr. Nath, no point in taking up the camera matter because Mr. KL is not there. We only wanted to tie up the thing.
Yes.
He is not available in spite of all the efforts. Then we forgot this proposal of Mr. KL.
The victim possibly.
We made an attempt, we say that we failed in view of the absence.
Yeah, so Julius.
Yes, where is Mr. KL? Ask him to come whenever he's free.
The victim has come, Lord. They have-
Both the victims have
Yes,
come.
yes.
Sorry.
I senior and help the victim, Lordship.
No, but we wanted the person will help to come face to face so that we can sort it out, arrive at an agreement and put it in a part of a judicial order.
Okay, Lordship, he will come after.
He's coming after some.
Okay, Lord.
Let him come.
Foxtrot comes on. Just a minute. And Mr. Nath, if he comes also, we wanted to involve the State Legal Services Authority to be the intermediary party to make this arrangement final. Because otherwise you can't leave him. কিতাপখন নাই No, Ghosh.
Yes, Lord.
What are the provisions in the POCSO Act for rehabilitation of the victim?
Under the
Under which section?
compensation scheme,
No, that is section 357A. That is different. Is there any provision?
I just need to check, go through one.
Mm. No, because we are always holding this conference, etc., saying rehabilitation. It's also an equal important.
Yes.
Is there any statutory provision for rehabilitation?
Specifically under this, that I don't think, it comes under the victim compensation.
Victim compensation is for any kind of victim under the
Yes, Lordship.
CRPC. It's not confined
Yes.
to POCSO. Uh,
This aspect, I'll just go through once, Lordship, and I will.
No, means number of conferences I have seen. One of the main topic is rehabilitation of POCSO victims.
Yes.
Where is the statutory provision? Mr. Nath, is it there?
Under, under 357A, that is the,
That is a victim in general,
Yes, Lord.
not confined to POCSO.
Yes, Lord.
Thirty-three 8. Procedure for special court, that one.
33A. In inappropriate cases, special court may, in addition to punishment, direct payment of such compensation as may be prescribed to the child for any physical or mental trauma. That
CRPC concern. Nice. Yes, Mr. KL. Yeah, the person is ready. Is he available today?
If I get information, I'll arrange it.
Sorry.
Whether she want to go to some other place, where we'll take care of herself and.
No, we want the victim and the child mother has also come. We wanted them to interact together in camera with us. You also remain present and let everybody remain present. Mhm. Where is he from? Guwahati?
They are from Guwahati, Nagaon, Jorhat, different places. If I
If one of them comes also, it is good enough. The man in Guwahati, will it be inconvenient to come? But for this purpose, we fixed today. The child and
I'll make every arrangement if he agrees to work. If he provides information and have received, if he wants to go outside, then
and we wanted to formalize the thing through the state legal services authority, so that ultimately,
they may not be independent.
sorry,
Independently, they will provide all the assistance. And one NGO is there, they are taking care of this type of persons, and they take care of their needs, education.
Are you free now? Can we come? We'll talk it out, Mr. Na.
Yes, sir.
No, right now.
Yes, sir. Possibly my learned brother, he wants to talk to the VP first.
Yes,
And
we
then
can
only
do.
he will communicate to the.
We can
Yes,
call them
yes.
side.
No.
Pension.
Percent to, well, subject to what your lordship says, percent to your lordship's last direction. I think. I have a-
No, that is already done.
They have applied
Mhm.
and lifetime family pension, if he is retarded, he will get. So lordship may wait for couple of weeks, they will possibly, they have filed.
No,
for
no,
it.
that one we are not concerned.
Ah.
That will take its own course.
That they will get.
So that is a separate order.
Ah.
Other issue, we just were interested to go into it.
May take up the. In this case, possibly it cannot be necessary because family pension, lifetime family pension, there is no dispute about that, they will get.
No, this is, we understand, but so you say that we need not go into this question.
Possibly in this case, for this case. it
Not
cannot
for
be
this
necessary.
case, but once it is brought to the notice.
Please, sir. I would not.
Is family pension defined anywhere? No, and what a pension?
Family is defined. Admissibility is there. 143 Roman. Admissibility of family pension is there in 143 Roman 2. And definition of family is in 143 Roman 1.
So family pension is provided in 142, not 143. This is what we're trying to.
Yeah.
Notwithstanding anything provided 2 and 4, if a government servant after rendering minimum secondary. No, this is different. No. Family pension.
143.
140 is family pension. Except that otherwise provided in 142. 142 is a government servant dying after rendering
7 years.
7 years of service. A family pension not exceeding rate mentioned in 141 will be admitted in case of death of a while in service or after retirement or after at the time of his death, the retired was in receipt of compensation invalid retiring superannuation. In case of death in service, the government should be completed minimum 1 year of service. 142 is.
Otherwise, in this petition, when the issue, a factual issue is there. In the service book, possibly that there is no mention about this child at all. Now, if they can establish that.
No, but if it is not mentioned, but factually child exists,
That is
not
what.
mentioning is not make the child non-existent.
Yes, so once they establish that there was a mentally retarded
No,
child.
no, what we are totally on a this thought is still going on in my mind.
I have understood. I have understood.
Family pension is an independent concept. A particular amount is paid to the family of a deceased government servant. That is called family pension. It is Section 4 is family pension scheme. It's a totally scheme of its own. Okay. 143 provides for family pension will be paid to certain persons under certain circumstance. Okay.
143C.
143.
One.
Because family pension is 138.
Yeah.
That is by virtue of the scheme, and it shall apply to all whom pension, right? The rules shall have effect from the 1st January and applicable to railway pensionable, except on a family pension not exceeding the rate mentioned in 141. So 141 mentions some rate, and this is called family pension. Okay.
Right.
Then comes 142. 142 is an exception which says that after rendering minimum of 7 years, if the government servant dies, then up to the date on which he would have superannuated, family pension will be 50% of the basic. This is as if the government servant, who he would have got as pension, not as family pension, had he lived beyond the age of superannuation. So this is 142 is an exception.
Yeah.
So therefore, 142 begins with notwithstanding anything 40 and 41. 40 provides for pension, 41 provides for the rate of pension. 143 provides family definition of family. Who all will be entitled to this family pension? Fine. 143C being unconnected with 143 makes an entitlement of the family pension provided in 141 to a special category of people where the deceased has a disabled child who is unable of earning. This is what I'm trying to ask you since the beginning. 143 will make the entitlement to the category of people mentioned in 143. That is, whoever comes in the definition of family, wife, as long as she lives, sons and daughter up to the age of 18 and 21, daughter possibly after unmarried, some further provisions. No disabled child will get anything under 143. Disabled child, by virtue of also being the status of a minor son or daughter of the deceased, may be included in the definition of family under 143. By virtue of that, he will be getting something. Irrespective of that, 143 gives him an independent entitlement. After he attains the age of 18.
Major.
This entitlement is
Different.
different. It cannot be in any way linked up to it 143.
Family pension.
This he will get it even if the mother within the being the definition of family under 143 is getting or not. Disabled will have an independent legal right of his own to get it.
This is what you wrote.
This cannot be linked up with that the mother is getting family pension. So till the mother leaves, you will not get. After mother, you step into the shoes of your mother. It's not correct. This is what I'm trying to understand from you.
My submission will be like this. This provision is my understanding of subject to what will be. Even if there is a handicapped child.
See,
No, Lordship,
let us put.
give me what I'm.
Unless I will
trying to
hear
say.
you. No, before that, I put you one more aspect. This disabled child, when he is the beneficiary of the pension before he is 18, being a family member of the deceased under 143, he is only a beneficiary. He is not entitled to anything.
Along with that,
Entitled is the mother. He is only a beneficiary of that one. But once he crosses 18,
independent.
he is an independent entitlement. Merely because you are a beneficiary along with the mother, as long as the mother lives, that will not, should not take away his independent entitlement. Please look at it from this point of view. Otherwise, we all confuse. Family pension is 143. Family pension is not 143. It's provided in 140. Rates are provided in 41. Who all will be entitled is 143. Further entitlement 143C. If somebody gets it, give it to him.
No, no, 100%.
If the law has
Yeah.
providing it. Because after the law has been provided, we have difficulty in giving a truncated interpretation and say that,
Right. Your amount would be-
or if you don't want to give, don't frame that law. Don't give. No one is compelling the state to give.
Right.
But once you give, don't try to
Okay.
curtail it. And I think this is the interpretation of all, these are all beneficial provisions. And the principle of interpretation of beneficial provision is always from the point of view of the beneficiary.
Right.
Today or some other day? Up to you, as you are convenient, comfortable. Yes, we did not hear you. We are taking up on our own other issue. Your issue is already decided.
Decided.
As per your lordship order, we have made the representation.
No, we are not interested also. That is your that is your problem. Here we are taking up almost in a manner of a suo motu taking it up on your listing.
Then everyone 6th Wednesday. Or
Not Thursday, day after.
day after.
Because we will lose track also no, after a long time.
Today,
Today is Tuesday, Thursday, day after. Let's see if a different interpretation is required. If it is required, we give. If it is not required, we'll close it.
30th.
Your number
After
with you,
taking
3 weeks
it,
time. Correspondent number 5.
1 week.
Apply.
3 weeks. 3 weeks. Item 14.
Apply.
Maybe.
18 December.
We may be allowed to 3 weeks time.
U Sharma for secondary
Yes,
education.
secondary.
3 weeks time.
Can I have the preferred date?
18th. Item 15.
Please, lordship. On last occasion, my lord,
Each Bezburwa for Dibrugarh University prays for 4 weeks time. Very easy.
and so far lordship, I don't know, respondent number 6,
Hmm.
no one was appeared on last occasion.
Respondent number 6.
Hello, I appeared for the Dibrugarh University, my lord. I had sent the affidavit. There was 4 weeks time given. It's like oversight on my part, my lord.
Mr.
Maybe
R.
next time-
Mojumdar,
next
Land
time-
Council appearing for the Dibrugarh University
Next time.
states that the instruction is received and the affidavit would be filed within
My lord, I can file within a week. Can file. Date may fix.
2 weeks.
Date may fix. I'm obliged.
My lord, respondent number 6, on last occasion and today also our absent. Let me note.
So
18.
somebody notice served.
Notice of how.
Did anybody appear?
My lord, on 11/10,
Somebody appeared.
on 22nd August, Mr. R. Deka was appeared on behalf of respondent number 6.
On 22.
Yes. R. Deka, 6 private respondent. For private respondent. Private respondent will be in a site.
Is it the right order? Mr. Bhuya just heard Mr. Bhuya for the petitioner, ADAS for 1 to 5, and R. Deka appears on behalf of respondent number 6. Then it says, peruse the office note of 6.2 regarding service on 6. Notice on number 6 shall be deemed to be complete. So normally when somebody appears,
Yes.
we don't write anything beyond that notice is complete or not
Like,
complete.
clarify, my lord, this Ardeka is my associate.
Huh.
Perhaps when he made a statement for APS for 6, it's not correct.
May not be
Ardeka is
correct.
my associate, my lord. He appears.
Normally what we write,
Yes.
suppose Mr. Mozumdar appears. Mr. Mozumdar appearing for so and so makes this. End of the matter of service. Service is deemed to be complete.
That should be.
We don't provide anything further after appearance that service is accepted to be complete.
And
So it appears little inconsistent. That's why I'm asking you.
And lordship, my understanding is submit that our.
Ardeka is my
He is
my
associate.
associate.
Huh.
Pritam Deka is my associate.
Then second part is to be admitted, deemed to be service.
the other part
Because
I'm-
of office note is concerned, AD already. Hard.
Track consignment report.
Yes.
What is a track consignment report?
Postal report,
What is the evidentiary value?
because it postal, it itself
Mr.
reflected.
Bhuya, what is the evidentiary value? Where do you get the track consignment report? Website.
The outside.
Information in website has no evidentiary value.
Yeah, my lord, from the website, if within the stipulated time.
It's
collected,
a presumption. Not supported by law. It's only an enabling procedure that is adopted by the registry. But ultimately, it's of no use. I'd taken up with the registry on this aspect, I think last week.
To clarify whether service upon respondent or seek.
Best
Copy
is
doc.
dusty, number one. Or we have also, did it order to delay postal department, or? No, no, it has a heading appear for good silo. No, in judicial order to delay. And it will put us in this column. That a Therefore, we have fixed a matter. I think another matter. We'll sort out this track consignment aspect. It's my feel it's
There's
almost
one system where, my lord, if we make an application to the postmaster there directly, then a copy is given first, it has been served on so and so, and they seal and they give.
that's
the-
certified. Certificate is
the
different.
Certificate is, that option is.
My
always
lord, so far, my lord, respondent number.
No,
2,
we intend to pass a judicial order requiring every postmaster of every post office to submit a report before the court, whether it is served or it is not served. Because consignment report has no evidentiary value. It's only information available in the website, and that to delivered. To whom delivered is also not established. Postman had given it to somebody.
Lordship, so far other respondents concerned regarding office note 13/12/2022. It has reflected that the item delivered on 6/12/2020
To whom?
to all the respondents except item respondent.
How do you know it is delivered to the respondent and not to a non-respondent?
On that assumption, my lord, service taken.
Under which provision of law?
But, because it has not challenged, because.
No, under which provision of law you were drawing the presumption?
When my lord, the address found correct, and to the correct address.
Section 27 general clause is there.
General clause.
Read the section complete. Don't read it half. Complete is unless it is objected to by the other one. Now, in case of service of notice by a court, where is the occasion for the other one to come and object? So entire 27 is not satisfied. So 27 is also not applicable.
The official respondents I appear. It's not difficult.
Official respondent is not difficult.
1 to 5 I would appear, but.
Mr.
6,
Bhuya, in other words, it's a sheer wastage of time. The day the judgment is passed against that man, he is going to file an application. I was never served. All the efforts of the last few years of everybody gone. It will be a fresh beginning. So why don't you make the fresh beginning right now? Understood?
And distance is Dibrugarh, my lord, and I have to.
Go and serve with Dusty. Go and serve with the registered post. Get a certificate from the postal department whether he has served it on this man or he has not served it on this man.
All lordship direction may be given to the registry.
Why should he give a direction to another respondent merely because you have made him a
Because
respondent?
on that office note, other respondent service already taken completed.
Other
On that
respondent, no difficulty. Mr. Mujumdar is appearing. No difficulty there. We need not go to that question.
But except respondent number 2, respondent number.
Adjourn on the prayer, Mr. Bhuya. Do anything you feel like. Go, proceed.
My lord,
See what is there in your next
my
item.
lord, next, they
Sorry, no,
because they have
not required.
on last occasion also they short time.
I'll file.
That we already-
That was the first.
4 weeks time later. Regarding service on respondent number 6, the question remains open as to whether it is actually served or not. As the note of the Lajima court is based only upon a track consignment report, which has no evidentiary value under the law. We keep it open. Next item.
Item 16.
Or if you want to take fresh steps, we can allow you.
Regarding. Regarding 4 weeks time to file affidavit.
Sorry,
4 weeks time to file affidavit.
4 weeks. Which department? Elementary,
Secondary.
secondary.
My lord, one thing, my lord, in this case, on earlier occasion, notice was not issued upon the headmaster. They have a
Upon the,
headmaster of the state. Whether I may be allowed to take step upon the headmaster.
why it was not issued?
Now,
So-
what was the opinion that respondent
No, is there a reason to not issue or
not issued?
inadvertently?
What was the opinion that pending council will be present?
Hmm. It is noticed that when notice was upon respondents was issued by the order of 8/2/2023, inadvertently issuance of notice of respondent number 5 was left out. Notice by registered post,
As well
steps
as
3 days,
As well as
by Dusty.
Obliged.
17.
We have filed our affidavit of opposition.
Yes, Mr. Mojumdar. Technically, we accept you have no legal right to be regularized. But what about the service extracted?
That is what I was trying to.
Hmm.
Just allow me to. That he has.
We have already framed a question.
All of that he has.
Will it not
got
violate Article 23?
Look,
And also the principle of law of torts will also be applicable.
that is what I was trying to tell. It is only in 2021 and 2023 that after that post is filled up by us by an advertisement, even when the post was advertisement, there was nothing to be said by the petitioner. When the post has been filled up, because it does not have the qualifications, even at that point of time in 2008, or even as of today, he did not have the.
No, we are never
qualifications to
asking
be-
you to regularize. Nor we are
That is what I was coming to, my lord. This management informs us about this situation only after the post has been filled up. So all this while, from what I have heard from the department had no knowledge this person was allowed to work.
No.
Lordship will find from their documents itself.
No, even if I accept that statement to be
My
right,
lord.
somebody is utilizing this service.
The managing committee. at
But
that
managing
time-
committee, is it a private separate entity?
My lord, managing committee for the law, it is
See.
framed as part of RTA.
See. Let us go to that newspaper example,
Yes.
which we all read in the law classes.
Now, my lord, that has also been answered by the managing committee in their appointment letter itself.
What?
May I read the SMS part? চকীদাৰৰ খালী পদত নিযুক্তিৰ বাবে কৰা আপোনাৰ আবেদন মৰ্মে যোৱা 12/7/2008 তাৰিখে বিদ্যালয় পৰিচালনা সমিতিৰ সভাত আলোচনা কৰা হয়। যিহেতু চৰকাৰৰ নিযুক্তি ক্ষেত্ৰত পৰিচালনা সমিতিৰ কোনো হাত নাই তথা চৰকাৰে দিয়া নিযুক্তিহে সন্মত আইনসন্মত বিধিসন্মত কিবা
বিদ্যালয়ত পৰিধানযোগ্য।
পৰিধানযোগ্য তথাপি সাময়িকভাৱে বিদ্যালয় পৰিচালনাৰ বিৰাট অসুবিধা হোৱা পৰিস্থিতি চৰকাৰৰ পৰা কোনো ধৰণৰ নিযুক্তি নোপোৱা পৰ্যন্ত আপোনাক বিনা বেতনে বিদ্যালয়ত
Can you, Bina Botane, that condition, is it acceptable in law?
he
No.
went in on that.
No,
So
sorry.
therefore, my lord, when he says that I'll give it free of cost.
No.
If he gives it free of cost, after he's won that I will pay you. If you want to do it, you can continue to do it. That was in 2008.
That, understand.
Then, my lord, he goes on at, then 2000, the next letter is of 2021. The appointment in the vacant post comes in. There is no issue.
Mr. Mojumdar, we are not at all examining whether the person is entitled to be appointed or not. That chapter is over already. Under the law, under any condition, is taking the services of a person can be done, and that too by a that
It
too
was
by
an offer which,
that too by a dominant employer.
well, we were not his employer. No, neither was the school, neither was the managing committee. No one was his employer at that point of time.
Then
His father expired on the
no,
post.
then who took his service?
Well, his father.
No, who took his service? Who took the service of a man sitting whole night guarding the school?
The idea of perhaps managing committee at the consider at that point of time and the continuing managing committee
I
is
know.
personally responsible.
I know, but it doesn't matter.
We will not.
Mr. Mojumdar, suppose in a house today, you are the owner. You also have a servant.
Yes.
The servant engages a daily laborer. Okay? And the daily laborer does the work for the whole day. At the end of the day, he says, give me my wages. Can your servant take a plea that I have engaged him on a condition that I'm not going to pay him anything? Number one. Number two, the owner will take the, hey, my servant has engaged him. I don't know. The servant is also a servant of the owner.
When the servant my lord himself says that the owner is not responsible, whatever the owner.
Maybe. So the law will require the owner to be responsible. And if there is a arrangement between the owner and the servant, the owner who is going to recover it from the servant.
If the servant
take up-
engages in his own
still-
capacity.
still.
would it stay?
No, if the servant engages for the doing of the personal work of the servant, it is different. But a servant is engaging for doing the work of the owner. Find out the law, Mr. Majumdar. I think these principles are against you. And when there is also a principle of dominant employer. When the dominant employer engages somebody in an unacceptable term, that term is unacceptable and arbitrary in law. Even if you have made one line there, make him to say, without bina betone word has no sanction of law. There are decisions. Same principle will be applicable. Otherwise, entire Article 23 will be redundant. Article 23. It's a fundamental right.
This is allowed, my lord, then the implications will have
Sorry?
anybody coming down with a certificate, saying that I was the employed. So and so.
No, no. If you
2008,
say he was
managing
not
committee,
working, make the
he will
statement.
not be able to curb the.
Don't allow that man to. He's a trespasser in your premises if you don't allow him.
The officially,
Mr.
there was no communication
Mr.
once that this man is working.
Mr. Majumdar, suppose today Madam Chutia starts going inside your house, all the time interfering, no, I am going to do work in this house. You don't want. What is your remedy? File a complaint of trespasser against Madam Chutia, that this person is unauthorizedly entering my house and doing this thing. But if you don't do it, time to time, you just keep on reminding, mind you, I'm not going to pay you anything, but keeps on doing all kind of work, and you are enjoying the work, taking the benefit of the work. The circumstance is different.
Sometime I'll just.
Day after tomorrow. Day after tomorrow.
Lord, besides that, my learned friend is submitting that there was no communication in between. I made several representations.
Nothing here.
I made them
Understand.
known that I was appointed.
No, we are not
Like-
even going to that aspect for the time being.
Madam, obliged.
But mind you, don't read it from the point of view we are asking to regularize or give any regular benefit. Something for the value of the work taken. Already taken, not all future work also.
There are annual inspections for the last so many years. I'll try to have those records called in, whether he was found present, whether such a man. is
No,
reflected
all
anywhere.
those records pertain to the right of a person to be regularized.
No, whether he had, in any place we can find that whether he had rendered service or. This was a letter of
No, no.
2008 appointment.
Understand?
So
Headmaster
to
given
give
a
them money, to give him money for service rendered, whether he rendered service or not
No.
is something we will. require.
There is a presumption he had rendered service unless the burden you discharge that he never came to
Yes.
work.
No, respond number 4 is submitted affidavit, my lord.
The
In
the
support of
headmaster, if you are
the
saying, we'll have to take a statement from him. We do not know.
Respond number 4 is
Do
given.
whatever you do. It's a public law
Submitted.
remedy.
Yes, yes.
Now don't try to raise the issue, say private dispute, now go for civil suit.
No, no.
You prove
I
that you
don't
work
know.
it.
That I
Please
will
don't
not-
take that stand.
that I will not-
Don't go to that extent.
I have never done it, but I will not do it.
We are deciding only the principle. This is very frequently happening.
One thing that will be, what I feel will come out good is, at least there'll be more diligence in finding out who are actually working
Find out.
legally and.
If you bring in authentic material to show that this person after obtaining order never showed the face in our school,
That's it.
now only try to take advantage, tell us that.
That
We'll
is one
look.
part, and the department trying to keep a control on who is actually doing what in the school. Which persons are roaming about in the school.
They have not
With the
denied
permission
mine.
of whom. That has to be.
Oh, in the night, this man is sitting in the school, guarding the school or not, who will determine?
Well, this appointment itself.
No, my lord.
This managing
Affidavit,
committee has to answer, or the headmaster has to answer as to when he was not appointed by the department. How come he was there in the night? Someone has to, headmaster has to answer for at least the last 2 years he's there.
No, answer.
He has to give.
Answer and tell
No,
us.
government
Once we
has-
start
And
tightening that,
if it's who is actually liable, it's between you and your headmaster and your
Exactly.
school. Find out.
that will lead to a situation where we can tighten the noose.
Yeah.
So that people, this.
No, that is for
these cases
future.
will not come up.
What about the past of this man?
That I'll have a look at.
no, my lord, they have not
Tightening
denied.
the
mine.
news will be for future.
We'll have to close that.
Taking the service for almost how many years now?
More than 13 years, my lord.
2008.
My lord, they have
15
admitted.
years.
by the
If he
LPDB.
know.
They have admitted my service, my lord. Now it doesn't lie on his mouth.
Madam,
Yes.
Madam Chaudhary, please don't get excited.
Yes, my lord.
Don't get excited. We don't have a
LPDB is there, my lord.
We don't. But somebody has to pay something. We don't know how much, but something. Day after.
The fourth or the fifth.
Sorry.
Would it be the fourth, fifth?
What I think number matters are already fixed. So this kind of matters. Pass the day. But don't try to.
I will not. What has fallen from lordship is only what will be considered.
No, don't try to defer it to an extent
I
that
will
it will
not.
become. Can think I'll take it somewhere else.
No,
Don't do that also.
that has never.
Because we have already heard it for quite some time. This matter.
On another earlier occasion, I had the obliged.
I think about actually, Mr. Ask your authorities also have a discussion. Be a little fair, pay something and bring an end to this practice. Because now what is happening, because no one has gone into this question, everybody is saying, let it remain as it is. Under the law, we have a right to oppose. You are not entitled to regulation. We are not going to regularize you. As you are coming on your own, go on serving. Let me enjoy your service.
On the fifth side.
We don't ask you to pay a very hefty amount also. Say something that the desire of the person is at least he feels that I got something.
When it is fallen from, the future will not be affected by this. I can perhaps.
Future from tomorrow, ask him not to come. In spite of you asking if he comes, file a FIR of trespass. If he enters your property to guard it.
Item 18.
My lord, item number 18 to 22. These are matters of a few students who were alleged to have committed an act of ragging on another student, due to which he had to jump from the second floor, he got hurt, and then there was an inquiry held, everything was done. Ultimately, my lord, they were punished with expulsion. Thereafter, they approached this honorable court, matter went up again, it was wanted back to the university, Dibrugarh University. Dibrugarh University this time said, it is proved, we keep in view the future of the students. This particular year, they stand rusticated. They will take up this semester, these courses.
Means they lose 1 year.
They simply lose 1 year and nothing further they lose. Time has not passed now. I had my instructions. These students are actually behaving themselves. Number one. Number two, there is no incident of any reported ragging in the Dibrugarh now.
So are you
Purpose is,
satisfied with the 1 year, losing 1 year?
The only thing, I had a discussion with him in the morning. And the only apprehension is that this rustication of 1 year may at a later point of time sometime come up in their career saying that you had one thing rusticated into difficulty. If there is
That's stigma. We remove the stigma.
Lordship says, if it falls from lordship that what they have punished, we keep it.
No, punishment we modify, the punishment without stigma.
Yes, it will be a punishment. Yes, definitely. Our purpose is sir, his purpose. They are attending classes now, except one of them who has left the course.
Ragging is a fun, but sometimes it's carried too far. That's a difficulty.
The only issue here
Means fun is sometimes converted to hegemony. That I am the one for some time you are basically here to serve me.
It was not kept till there, my lord. It was kept like one person had to flee. He jumped from the second floor window, broke his spine, had to undergo surgery. 2 people lost their right and left ear bearings, 1 each.
Those victim students.
Victims, they were slapped till the point their ear.
Slapped also.
So that part all done, the victims, they are also facing criminal cases. So we are not trying to pursue it in our level now. If they can get an acquittal there, it's good. Because this order may also hamper their criminal trial. So therefore, if it is an order without a stigma, loss of 1 year, we all give it a quietus, we will not interfere again. Let them pursue the course and go. Is my instruction. Those people will not have it from my mouth.
We can close it that.
Yes, we can have all the matters. 18 to 22, we can have.
So when do you want to have it? Today itself?
Today itself, we can be closed.
Heard Mr. T. Dury, Land Counsel for the petitioner, also heard Mr. Common order. Can you pass a common order?
Yes, yes.
Or individual order?
Yes, sir. The same is here.
R. Muzumdar for the learned, for the respondent Dibrugarh University, authorities of the Dibrugarh University. All of Dibrugarh University.
All are
Oh,
different.
Same is.
Only the subjects are different.
The petitioners in all the, how many, 4 or 5?
5 years.
In all the 5 writ petitions have raised a common cause of action to the extent that all of them are students in various courses under the respondent Dibrugarh University and were admitted in the first year course for the academic session. Find out.
Not first year course, your lordship. The most-
No, respectively,
Oh, yes.
everybody had a first year.
Yes,
No
yes.
one can be there
Sorry.
without first year. In, for the academic sessions, so and so, so respectively. Give the sessions. In course of the study, they were later promoted and were students of different semesters. In which year ragging took place?
Report is of 27/11/2022.
When
And there is an FIR.
there is a FIR lodged by the authorities in the Dibrugarh University, by the, no. All the students, petitioner students are alleged to have been involved in act of ragging of the, what do you call new students?
They call it freshers.
Freshers.
Even
Freshers,
in the anti-ragging, you know, it's special.
freshers, কি করলো?
Alleging to have been involved in the act of ragging.
Ragging the freshers in the university. And the allegations are there that the act of ragging went a little further. Which had affected the freshers in different ways. The excess of lagging also resulted in FIRs being lodged by some of the victim freshers dated 27/11/2022 before the officer in charge of Dibrugarh Police Station, resulting in Dibrugarh Police Station case number so and so under section so and so. Initially, they were rusticated for
They were expelled.
expelled. Later on,
Some were expelled, some were rusticated. Later, when they approached this court, we decided to, we were directed to take care of the appeal. We sent the matter back to the.
and now it is rusticated for 1 year.
Yes, that lordship will find it page 70, the order.
70,
Page 70 of the.
70.
85.
On the administrative side, certain actions were taken against the petitioner students. Is it page 43?
Initially, yes.
Initial order
yes.
page 43, I think.
Initial order is page 43.
Kalyan Dutta at 4, your lordship.
Serial number 4, he was there.
কি বলো?
No, this is suspended.
Certain actions were taken against the petitioners, as a result of which some of them were expelled from the university, where others were rusticated for how many? For life.
No, for a year, your lordship.
No,
For
Initially,
No, initially.
Initially, my lord, they were expelled.
Where they were expelled from the university.
Then-
Being aggrieved, the petitioners instituted WPC.
Not on this. I'm so sorry, my lord. Here what has happened is after the show cause notice, they have been punished for the first time. That was another back. There's another 2-3 back. I'm sorry.
Now here
Yeah.
what to write.
They were
See,
suspended.
mind you, we are dealing with 5 petitions.
Yes,
So
ma'am.
facts must be common.
Common. Here, the lordship will find, at page 59,
Hmm.
we gave them a notice from the NTA committee.
No, where is the ultimate punishment?
Ultimate,
Means, we don't,
First punishment is at page 70.
7-0.
70. They filed in, which is page 70.
Same punishment for everyone here also. Page 70.
No, this is not expelled.
No, not expelled. I'm sorry. There are 2 batches of petitions. I got little confused. These persons were,
Okay, do one thing.
I'll give a synopsis.
Give a small
Tomorrow.
synopsis so that we can dictate the order. List of changes. Make out a little, if possible, a tabular form. Petition, petition number, read petitioner, this was the original punishment. Court case number, remanded back, final order. And there.
Provide it tomorrow, your lordship.
Tomorrow you can. Kali paribo?
Very good, yeah.
Yeah.
Let it be.
5 তারিখে।
Let me fifth, my lord, we'll have it. Yep, sublet.
23. No, separate.
None, it is for a petition, we might as call list again.
24.
Yes, ma'am.
This matter relates to compassionate appointment, my lord. Here the petitioner's case was rejected by the DLC
Page
without
number.
assigning any reason, my lord.
Page number.
Page 27, my lord. Serial number 3030, my lord.
Yes, Madam Bormon.
Yes, but I have the original record, Lordship. The case was not recommended because the petitioner has the late submission. Lordship. As per record, Lordship. On 70/2010, Lordship, the application has been submitted, Lordship. As per record of the deputy commissioner. Lordship.
When the man died,
In 12/3/2007,
12th May
12 March 2007.
2007. Huh.
But
And
as
when the
per
application was made,
3/7/2010, as per our record, Lordship. But petitioner has an annex, Lordship, one application, Lordship, submitted before the headmaster, Lordship.
That is 24/4/2007,
But
my
that
lord.
was not in the record.
It was duly forwarded, my lord.
But lately it's.
consider it.
But
Hmm?
the earlier.
No, not on record doesn't mean not submitted. But once it
I
is,
think Lordship, headmaster has not forwarded the same to the.
so headmaster is a part and parcel of the respondents.
As per record of the education department, it is 7/3/2010.
So next one must have been a reminder or something
Yes, Lord.
that was placed.
Yes.
See, under the law, if you get it or not.
Last occasion, Lordship, we have directed to Lordship to file a affidavit, Lord, showing the discrepancy, Lordship. On 10/11/2020, the notice was dictated the order. But Lordship, the copy has not been passed to us, Lordship. That's why. The record is available.
Your record is there, it's okay, instead of going to a technical thing, or you want time.
Lordship, is to, after verification of the, or
No, we'll allow you to verify and place it. And if it was not submitted, you pass an order, give it to her. If the earlier application, according to you, after verification, if it was never submitted,
yes, Lord.
you inform the petitioner. You don't have to place it there. Instead of verifying and submitting affidavit to court, we direct you to verify and inform. SB Chaudhary. Habibur Rahman was grade 4 in Muhibur Rahman MB school, died in harness on 12/3/2007. And it is claimed by the petitioner that on his death, an application for compassionate appointment was submitted on
24/4/2000.
24/4/2007 before the headmaster of the school concerned, which is annexed as Annexure E to the writ petition. The Annexure E application also contains an endorsement of the headmaster dated 24/4/2007. Providing that it was forwarded to the district elementary education officer for doing the needful. But however, as nothing further was done, the petitioner made another application on
On 3/7/2010, Lord.
3/7/2010, which is stated by the respondents to have been placed before the DLC of Karimganj district in its meeting dated
Being dated
17/6/2013.
7/3/2013,
June.
76/2013, but was rejected on the ground that there was a late submission of application. The petitioner raises the grievance that the original application was submitted on the 2007, which was forwarded by the headmaster, but for reasons unknown, it was not placed before the DLC, whereas the subsequent reminder application was placed before the DLC, which was made on 2010. According to petitioner, had the original application been placed before the DLC, it would not have been rejected on the ground of any late submission. In view of the above, the respondents in the elementary education department is directed to make an inquiry as to what happened to the application submitted by the petitioner on 24/4/2007, which again was forwarded by the headmaster of the school to the district elementary education officer. Upon the inquiry, if it is found that application was made in the year 2007 itself, the same be placed before the DLC for a fresh consideration. And if the inquiry reveals in any conclusion that the application was not submitted, the result of the inquiry along with reasons be informed to the petitioners. And in such accordingly, if the application is required to be placed, it be placed before the next available DLC of Karimganj district.
25 orders.
It's a matter regarding compassionate appointment. Formula 9/8/2012.
It's an application of 2015.
15.
Dismiss.
Well, no, what is happening here, Miller? Is that?
No, let us dismiss it.
But blood.
No, if the petitioner has no urgency for 8 years, why should now we send it?
Service on the respondent number 8 could not be completed because our whereabouts are not known. That's the reason why it has been pending.
Who asked you to make the number 8 a
Because well, she has been, well, in spite of not being recommended initially, she has been appointed. In the same
Now,
recommendation.
after 8 years, do you expect us to cancel number 8 and give it to the petitioner?
But we could not serve the notice by, in fact, file an affidavit, her whereabouts are not known. We tried to gather information which has not been able to.
So if somebody is appointed, she must be serving in the government somewhere. Find it out.
That particular school where she was appointed is not, she's not there. That's the reason we're filing an affidavit.
Yes, what to do now? Now it is served or not?
No, it could not be served. This is the report.
No, report will. If you cannot serve, what do you do? Is there any provision of law to go ex parte?
Paper publication is service only.
Paper publication. Order, CPC. Order 17 or what it was? Paper publication. Order 9.
Under respondent number 8 has been serving as a grade 4 in Batavari UC Decca Janajati High School.
Then we can serve, because initially they were not divulging the information, but we can serve.
Mr. Dotto, we are a little disinclined to go further in this one. If for 8 years you'd have made no endeavor to find out where the man is working and the notice could not be served, after 8 years, rightly or wrongly, a man is working, why should you disturb that man?
Understand, but then here what has happened, where there was a change of councils also, all the councils were earlier there.
Ultimately, for the litigant, it's a continuity.
That's true, madam, but then unfortunate case.
Do you think it will be very appropriate? And now he'll serve notice. He'll come and appear. It will take another 3 to 4 years for that man. So, after 12, 13 years,
Following from a lordship, my lord.
Mm.
But here what has happened, my lord, I was recommended, she was not even recommended, my lord, and yet she was appointed. My lord. On the basis of a subsequent, my lord, reconsideration, my lord, which couldn't have been done.
which one? Page number?
The lordship will find, my lord, at age, my lord.
You could have taken an order without making that person a respondent.
That's good. Page 28, my lord.
In fact, sometime back, we have passed an order that if a grave illegality was done to somebody, legal right violated, we directed that right to be redressed. With the other man illegally occupied, you do whatever you do,
Perhaps that, my lord,
without making the person a respondent.
but since it was made, my lord, now, my lord, I came into my latest statement, page 28, my lord. Petitioner is Jitu Taponda, serial number 9, my lord.
Page number
28, my lord, serial number 9, my lord.
So this man is appointed without recommendation.
Second, my lord, serial number 12, my lord, Jyoti Rekha Saikia.
Page number
28, my lord. I was recommended, my lord. Jitu Taponda is recommended. Serial number 9.
And
my lord.
how it got reversed?
My lord, serial number 12 not recommended.
Uh,
Now the SLC meeting lordship will find, my lord, at page 55, my lord.
Page 50.
55, my lord. Now this lady, my lord, in a subsequent DLC held in 2013, after it was rejected in 2012.
Just a minute, Jyoti Rekha. Where is Jyoti Rekha?
Second, my lord. Lordship will look at page 55.
Uh,
Serial number, my lord, second, my lord, 34. The second from the top, my lord.
the earlier DLC was,
My lord, 2012, my lord.
earlier DLC rejected is 2012.
12, my lord.
And where is the DLC recommending her?
My lord, that page, my lord, 55, my lord. Date of recommendation of the DLC, my lord.
And did the SLC consider your recommendation?
Yes, my lord. My case was, I was rejected for lack of vacancy, my lord. That lordship will find at page 61, my lord.
This is dated.
This is the same DLC, my lord, SLC, my lord. In the same SLC, my lord. Mike, on the basis of my lord, recommendation in 2012, I was rejected. And my lord, page serial number 24, my lord, page 61, last name, my lord.
No, this DLC is dated, SLC is dated.
SLC, my lord, is dated, my lord, 2014, my lord. 29, sorry, my lord. This SLC is dated, my lord, 26/8/14.
26.
8/14.
This is your rejection. Where is the approval of the other one? You
In the
said
same,
just
in the
now?
same SLC, my
The
lord,
page number?
page 55, my lord.
55.
my lord. Second from the top.
And where is your recommendation?
By the DLC, my lord.
DLC
DLC lordship will find me, my lord, in my writ petition, my lord, page 28, my lord.
28.
Serial number 9, my lord. And at bottom, my lord,
Just a minute, slow.
recommended for grade 4, SLC may take decision. And lordship will find below 12.
And just go a little slow.
My lord.
What is page 50?
Page 50, my lord. Page 50, my lord, is the.
I think same one as
Yes,
page 50.
yes, it starts with. No, page 50, my lord, is the DLC, my lord.
huh?
DLC.
You are recommended.
Yes, sir.
And in the same one, I think the other one was rejected. Where
Not
is it?
recommended, my lord. 12, serial number 12.
12.
Yes. But subsequently, her case was again considered in 2013. And on that basis, that recommendation, she was approved.
Where is that 13 DLC?
DLC is not there, my lord, but then there's in the state level committee, my lord, recommended page 55.
And I've seen that. Where is that recommendation?
Page 55. my lord.
Information is there, but where is the
DLC is not available with me, because in that case, I was.
the respondents to produce the recommendation of the DLC dated 23/4/2013, by which the SLC is of the view that the respondent number 8, Jyoti Rekha Saikia, was recommended. Madam Bormon will impose a cost of 5 lakhs in favor of the petitioner. Compassionate appointment gone. Pay the money. We'll hear you, not that this is a tentative possibility of what may happen. If a man is recommended by a DLC, another person is rejected by the DLC, keep that DLC, withhold it, don't place it before the SLC. In the meantime, constitute another DLC. This time you recommend the rejected candidate, place it before the DLC. DLC will reject the first recommended one, saying no vacancy, and give the appointment to the rejected candidate. Then you take the appointment. This is absolutely arbitrary, unacceptable in law. So we don't know. We don't penalize the respondent number 8. Let notice be not served. The state should compensate this man for having caused legal injury, and to be realized from the respective members of the SLC and DLC of the relevant time as well as the proportionate.
Verify that.
Sorry.
We have to verify.
We only want to see 13, why the DLC had subsequently recommended and against which vacancy. If the DLC by the subsequent act had again recommended against the earlier vacancy to which this petitioners recommend, that is even a further illegality. So that in lieu of compensated appointment, the family can survive with that money. Yes, something should not be done.
Yes, sir. What happened, Lordship, in Phantom?
Sorry.
Department has, Lordship, and have forwarded the application to the district level committee, Lordship, that without verification of the deputy commissioner, Lordship, they have recommended, Lordship, the earlier.
Which one? Early one, the petitioner.
So many cases, Lordship, that is.
No, it's time the authorities, we impose some good cost, which will be little pinching, so that you don't do all kind of things in future. And recover it from all the persons who are member of the SLC and the DLC of that relevant point of time. Now, don't take the plea that 8 years have gone by, they have retired and all.
Yes.
You recover it from them. listen so and so for further hearing
Item 26.
very shortly.
Deplorable.
It won't be beyond 2 weeks, don't worry.
My lord, after causing justice service on respondent number 6, my lord, I have filed my affidavit.
Accept it.
Yes,
This is contempt.
my lord.
Contempt, can it be served dusty? Even the court may have passed an order. Contempt, can you serve dusty?
Who has passed the order? my
Court
lord,
may
from
have
the-
passed, but
Generally, is my lord, there we need to give them notice, then they do not comply. Then, my lord,
read it is okay because
yes,
you just espouse your legal right. We asked them why you're violating the legal right. Contempt will lead to punishment, jail.
my,
Can you do it with just dusty?
my lord, that also he has received and no.
Yes, Mr. Kinchori.
It has to be reformed, not the.
The contempt, I think dusty will be,
But High Court rule says it has. to be
it is
reformed.
there. Yeah. Take service once again. Or if somebody is appearing, you are saved. Is somebody appearing?
Somebody, my lord, university, my learned friend has appeared.
No, who is this number 6?
Number 6 is the secretary, my lord,
Secretary of
higher secondary
higher secondary?
education.
Secretary.
That board,
Secretary-
higher secondary
secretary-
council. Higher secondary council.
My lord, not my lord, government, my lord, secretary to the government of Assam, C block,
Full education.
full education.
Secretary.
Secretary. I have to get-
List on 4/12/2023 to be taken up with WBC to blank with RKD to Mega Vaidane. To enable the postal department to answer as to why a registered notice sent by the court in a contempt matter, the postal department is not responding as regards service report. Will show us notice to the postal department. We may issue contempt notice on the postal department. I think that's the best thing to do. Don't you think so?
Under causes, my name should be reflected. in court.
That is a other thing. Your personal matter you take up with the court master. But don't you think it's time has come to take the postal department on board?
Report that generally does not come, my lord, not only in this case, my lord, many other things.
Yes, Mr. Dotto, what do you feel? Do you think the time has come to take the postal department?
They take everything so.
Now, see the inconvenience that is caused. Notice sent, no AD, no reply, no report, nothing. Do whatever you do. Are the postal department not obstructing the administration of justice? Is it not a criminal contempt?
I think. But in many of the cases I have found, they don't give any credence to all that.
Sanitary RKD method to logo di dibo. WPC, gimana sa dito? Net office. We'll take up on 4th. We'll issue notice on the postal department. And in the meantime, if you want, they can take something to your service. Dusty will be difficult later on. It would deal with WBC so and so.
Ordered 1910-20.
1910. What is this?
There is two contempt.
No, 1910 judicial order or office note? Judicial order. No, what is to be done? No.
That further review,
Sorry?
we had preferred a review application and that was dismissed. It cost of 50,000 if I'm not wrong. That
Cost of?
50,000, my lord.
3,000,
50, my lord.
50,000.
That we are processing to pay immediately, my lord. The other
The
part, my
cost
lord,
you are processing to pay immediately. Now this content, what is to be
my
done?
lord, I need some time, my lord. Mr. Christie was required to appear, but he had sent me only this instruction. Otherwise, the review part, we are completely.
Okay. Mr. R. Mojumdar, Land Counsel for the petitioner, has produced a communication dated
18/11/2023.
18/11/2023
11. Signed by.
Of the Deputy Secretary to the Government of Assam in the School Education Department, by which it had been informed that the review instituted by the respondent continuous had been dismissed. In the circumstance, 2 weeks' time is sought for filing affidavit in the contempt petition. List after 2 weeks.
28 and 29.
That one.
Starting this class. So.
Oh, I see. Number.
So after reasonable assessment of the entire matter, the atmosphere of the class, we had a constituted one committee, under the supervision of the previous staff, the retired ISO member of the class. That committee was instituted and any class member who do not have any objection, except everything under so-called chairman of the.
To have the election under Mr. Das.
I want not election.
No, 3 members have objection regarding what?
Regarding putting of this committee. Now, what I thought, this committee may be allowed. Go through the accounts of 8 years, whether there is any changing or not. Now, all these things may be sorted out. After that, election can be held. That way, there will be some solution. Otherwise, what I have found, I had an interaction of many members who are really educated and having the social background. So they are reluctant to participate in the election. And if they do not come forward, it will again lose hands.
Means the good elements don't want to face the bad elements. Do whatever you do, kind of a thing.
If they are all scared to the in the accounting system and all that, they don't want to come forward.
And Mr. H.S. Das is willing.
He has given.
And 250 persons are with him.
Plus member.
Are with him. Who are those 4?
One is Mr. Ranjit Chandra, one is Kiran Pianos, the one is Vedari. Another one I just forgot.
So these 4 people are against holding the election.
They are interested. Election.
Do anybody represent these 4 gentlemen?
No, not. I'll just subject to what my senior friend said. Elections have not been held so far. Now, perhaps there's a slight confusion. A letter was floated, perhaps sir has only floated that letter, saying that for betterment of the society, a committee needs to be constituted comprising of HSR. But elections have to be held, my lord, because the direction is to hold elections, my lord.
What I am saying, let this committee clear up the accounts and all this.
But that will take a long time.
It will not take much.
Because the accounting, but within a month, can. It was 8 years of. That will take.
No, hold the election, make all the persons voter, whoever wins will take over and take care of the society.
From my parents' side, I can tell you that we will go to the same hands and the accounting process will remain the same hands and clearance of all these things.
Why? They have the support of many people
Yes.
in an election.
I mean, those good people will not go there. That's the idea I have.
I understand, maybe you're right.
It's subject to a lot. That's my.
Mm.
I think it is for the betterment of the entire. Otherwise, this club will not. That's what I felt. And I don't think my letter will have any objection to that. It was betterment of the club.
Well, the only reservation anxiety that we have is the democratic process of election has, because we filed our nomination. Nominations are on record. So if the election is not held and we resort to a selection, my lord, then
Possibly my letter.
Nobody is resorting to selection.
The election will be there, but each committee will just sort out.
His submission is something different. That some better elements of the club
are
are
shining.
so frustrated, we are not going anywhere. We are not even participating in any election.
That is what.
Once that happens, the worst elements will take over the complete control. This is the apprehension raised. If you are in, your clients are the worst elements, you like the election to go ahead. Because we'll win the election minus the good elements and we'll take control. So this is the one way of looking at the reservation expressed by Mr. Decker.
My
And Mr. Dotto is a neutral person. He has no interest and he is only acting at the request of the court so that.
I understand,
Huh.
and we've been.
So who is your client?
My client has filed a nomination.
No, who is it?
Pramod Kumar.
So you will contest the election.
That's what I want to contest.
When it will be held.
Yeah.
But if the elections will be not be a proper democratic election because of some other elements,
Well,
it's you better you delay the election by some time.
that is fine, Madam, because
No,
as
that
we-
is not fine. That is the issue. What is raised by Mr.
Well,
Dotto.
I understand his concern, but that maximum participation.
Let us do one thing. I think people don't like good things to be done. Let the club make its own fate. What else to do? We have made some sincere effort. You have made some sincere effort. People are not liking it. Let us close it. How do we lose? How do you lose? Nothing.
Because I was thinking.
Let us close it. Let the club make its own fate. Do whatever you do. If people are not liking some good things to happen, let it prevail.
If I may just. Maybe a handful of people are not liking the stand taken by Mr. Datta Yadav. The whole issue, as your lordship had.
Or else what is actually wrong means
Anomalies in the accounts here. What has happened is for the last 8 years, this ad hoc committee which was going on, as your lordship went through the record. Because the tenure of the earlier committee expired and they continued because of the litigation that was going on. Now, there was some anomalies with regard to the account. Now, interestingly, now they are going to appoint, when Mr. Datta joined, this committee started that they are going to, they were showing in the minutes of meeting that accounts have been passed. But there was no person who was holding the post of any auditor Now they are going to appoint an auditor, which clearly shows that the earlier sanctioning or approval of the accounts were not done even by the appointment of any auditor. These points came up when the.
Understand. So you want now
He
to
wants
appoint
to
a
verify
designated.
statements of the earlier committee with the auditor, which they have themselves. Now, these things, the Pandora's box are going to open up. Some persons are afraid of the anomalies that will crop up because of this ad hoc approval of the various things. And this is the thing why I should not cast aspirations upon anyone, but the thing is, there is a attempt to stop Mr. Datta from proceeding with the objective he has in his mind. He has a clear objective which most of the members are supporting.
Yes, Mr. Rabha, what is your view? No, you are in favor of this committee going for the accounts, or you are? You are also with Mr. Deka, understand?
I'll just, if I may add one thing, but accounts needs to be settled, there's no question about it. I was not even a party to the prior committee.
No. Mr. Deka, we understand your good intentions. But a good intentions has also to be preceded by an assurance that true democratic process will be available. But if some elements are afraid of some other elements, and the other elements are in control of this manipulation one, then even if an election is held, it will not be a proper
That's why we
election.
have sir here, because so that.
Therefore, Mr.
Therefore, we have sir, so that.
So Mr. Dotto also therefore thinks that better the elements who wants things to be in order will come into the fray of or participate in election only when these are cleared up. So therefore, he says that clearing should be preceded before holding an election. And we don't find it to be.
That exercise, in fact, my learned.
I don't feel it to be very unreasonable.
My lord, I'm not saying it's unreasonable. What I'm saying is, my lord, in that letter which was circulated, it said that there will be a committee which will now govern the club. Now, my lord, if it's an ad hoc committee just to clear the accounts to facilitate an election in future, my lord, then there's absolutely no problem. But I think people may have misinterpreted the letter or whatever. I have a copy of that letter.
That letter can be modified by adding or deleting a few words if you are so perturbed with words.
Clarified, then perhaps what. The last page.
Which one is offending according to you? Which word?
My lord, the conclusion is, my lord.
No, which word is offending according to you?
My lord, the next committee of the club.
Where is the next committee?
The last paragraph.
I too have the opinion that every member would agree to cooperate with and is to
form the next committee. So.
Okay, we delete to enable cooperate with Mr. to enable him to bring
conduct the election.
Huh?
To conduct the election. If this committee conducts the election is fine, my lord. My lord.
It itself should not be committee.
It should not be the committee.
We'll clarify to that extent.
What I'm saying, for the purpose of clearing the account.
So they will do it. We'll clarify that. It is for the purpose of
just a time period
of clearing the accounts, and thereafter the committee shall do the needful to hold the election. Okay.
Independent election.
And this committee is specifically entrusted to take the club forward and also clear the accounts.
Only for the purpose of clearing,
Huh.
yeah.
Under the
And just
supervision-
one last prayer, Malad, a time frame, Malad, we are almost in December, Malad, February, the process. Very well.
Under the supervision of.
Yeah, sir is always gonna.
Mr. S. Total Senior Council enacting furtherance to our earlier orders had made a communication dated 18/10/2023 to the members of the Gymkhana Club, whereby a committee headed by Mr. H.S. Das, retired IS officer, who is also a member of the club, to be the president of the club for the time being. To be the president of the club, with the objective of forming the next committee of the club by following the democratic process. Next committee of the club. We clarify the communication dated 18/10/2023 to firstly provide that the committee headed by Mr. H.S. Das shall first look into and clear the accounting anomalies of the club, because of which certain members are having their reservations in participate in the election process. And after doing the needful, to make arrangement of holding the election by following the complete democratic process. I think this is good enough.
Yeah, and the time frame.
Under the supervision of the.
Under the supervision.
It needless to say that the elections should be held under the supervision of Mr. S. Total and Senior Council as ordered earlier.
Time frame.
The list again on so and so for a report from the committee to be headed by Mr. H.S. Das, retired IS officer, as to what had been done in the meantime as regards clearing of the accounts. Clearing them, then we'll fix a date for holding the election. After 1 week. After 1 week. List on so and so.
Committee members.
The list of the committee members so framed is also kept on record. Next week, he see what the financial thing he clears up. For doing the needful, Mr. H.S. Das may engage any authorized auditor stroke chartered accountant for doing the needful as regards the accounts.
Public.
And next time we'll say you hold the election now.
Right.
I think-
Item 30.
With service report as for office not dated service.
31.
List on a 4 12/2023 along with WBC so and so. Same, the postal department creating problem.
Item 32.
With service report as for office not dated.
33.
Petition allowed 2 further weeks time to take steps on the respondents. Where is the post?
34.
Basically, has not been issued, and during the period of pendency of this petition, he has issued two letters to the facilitated not in the record.
What is this? IS civil is for what purpose?
IS is for not completing the file and completely process with time boundment.
And the writ petition is for?
Also for the complete process of the file.
No, what file for what? Mr. Sharma, file is for what purpose? Pension, salary, appointment, retirement?
Payslip.
Payslip. you are not getting your salary.
Since I
Uh,
am getting a salary provisional basis. Since
Salary
2011.
provisional
It is agreed by the fixation of pay.
fixation.
No, no. My pay slip for the post of local superintendent intern.
Your appointment is a regular appointment.
Yes, regular, we have regularly promoted.
Little slow, a regular appointment. The post where you are appointed, does it contain any scale, does it have any scale of pay?
Yes, it was scale of pay.
It has a scale of pay. Why that scale of pay is not paid to him?
Because of lordship, the process for incorporation of this post, lordship, incorporation of works as superintendent in
No,
engineering.
no, where is the appointment letter? Let us see.
May I please verify?
We'll look in, where is the appointment letter? Page number?
Kindly keep on page 84.
84 writ petition. Does the Assam Engineering College has the post of workshop superintendent? Is it a sanctioned post?
Yes.
It is sanctioned against which scale of pay?
In the year 1957.
No, no. This post must be carrying one scale of post.
Yes, page 80. So lordship will get details in the letter, page 139. Or up. Correct.
Hmm.
The done take up.
Hmm.
Regarding instance of pay slip to be belong to the later by accountant.
Which one you are reading?
That is page
139, huh? Huh? Which paragraph?
Object.
Okay, worth of sanction was sanctioned.
I got letter number dated Geelong 26/7/1957, which is page here of June 22, and approved by finance Dr. Pattam I order number dated 15/7/2007. In the permanent detention order, letter dated PTO 171 dated Geelong 15/May/1971, a pay scale of 750 was saved for Dr. Superintendent and Assistant Professor Assam Engineering and approved by finance Dr. Pattam. Subsequently, above pay scale was next stated at 920 in the Assam Technical and Services 1981, to which the same is both for HOD Polytechnic and Dr. Superintendent Engineering College. After introduction of AICT base in the state, the pay scale of Dr. Superintendent Engineering College and HOD Polytechnic AICT in the AICT notification same 3,700 in the first AICT notification and standard at 10.9 meters. So the scale of HOD Polytechnic.
Mr. You're appearing for the finance department. It appears that in some of the ROP rules, the post of workshop superintendent was dropped. I think that's the only issue here. If it is dropped, you correct it.
Yes, Lordship, that incorporation only, Lordship, here the higher education authorities have also written to the PR.
No, we don't want so much of communication. When the finance department had adopted the ROP, it incorrectly dropped one post which ought to have been added. You add that post. You don't do anything beyond that. And wherever this post ought to have been added, you pay him, that is his scale of salary. How can all these unnecessary complications come on the way? See, suppose today I pick out a list of 10 advocates who will be assisting the court for something. Okay. Inadvertently, I drop your name. I put in only 9th one, 10th, Mr. Chaliha, I did not put. What will be the remedy? I'll correct it,
Yes.
put Mr. Chaliha's name as the 10th man, and it will function as it is. So it's a responsibility of finance department. If they have mistakenly did not mention the name of this post, you issue a correction and mention it. You don't need anything beyond that. It's a government post. It is sanctioned, mind you. Post is sanctioned in the year 1957 itself. This is only an inadvertent mistake.
Yes. Okay, I just need some time in order to get the response. of
But the man is not getting any salary. How will he survive?
Lordship, that payslip part is.
You get your salary through the payslip.
Yes, Lordship, some time may be granted so that.
Then who will feed him in the intervening period?
Lordship, a short date, Lordship, Lordship may pick a short period.
Send a packet of the daily ration to him every morning.
He's getting salary, otherwise, Lordship.
You decide, what, how do you expect a government employee to survive in life? You don't pay him. And that too, not because of any illegality committed by him, any fraud committed by him, any ineligibility, nothing. Some authority, while taking out the ROP, had forgotten to add the name of that post. So how can he suffer for that?
There is a possibility some salary was, he's receiving, Lordship, that is.
He's receiving salary.
That is what my learned
From where are you getting your salary without pay slip?
When I promoted, and the same scale of pay, what was original pay scale at the Assam engineering institute. That scale.
You are being paid the scale of your original post.
And sometimes something is added, provisional basis, it cannot be actually this one there.
Bring an end to it.
Lordship, so one short date, Lordship, in that period, we'll be able to open what is the stand and how soon we can clarify the grievance of the petition.
Speaking on the first, you cannot take it.
Oh.
Mr. Chalia, we don't feel you should be allowed to take a decision how soon you can do it.
No, Lordship.
See, it is. Suppose it's an issue where the court has to decide whether the person is entitled or not entitled, we'll give you time. We'll allow you to take your stand. But where is a case when because of inadvertent mistake, one post has been left out? For that, you don't need so much of time. Is the finance department trying to justify why they have incorrectly left out?
No, Lordship.
For that, we'll give you time. But here is it's kind of a clerical correction, that's all.
The correction, some time may be required, Lordship, but we'll.
Why do you need time?
To address the grievance only, whatever.
You need time when you have to look into some aspect, whether it should be given, should not be given, under what circumstances given, how much to be given. If nothing has to be decided, only aspect is a post had been wrongly left out, we have to include it.
Yes.
You don't need time for that.
The minimum time is required to include it,
2 days.
Lordship, within Lordship, on Monday, Lordship, by then we are going to.
The finance department to inform the court. Now, we have produced the communication dated 24/2021 from the Director Technical Education Assam to the Joint Secretary to the Government of Assam in the Higher Education Technical Department, from which it is discernible that the post of workshop superintendent in which the petitioner had been promoted was sanctioned by the government letter dated 26/7/1957 in a pay scale of rupees 350-25-450. Later on, when the AICTE scale of pay was introduced in the state of Assam, the post of workshop superintendent in the Assam Engineering College and HOD or Polytechnic in the AICTE and HOD Polytechnic as per the AICTE was fixed at rupees 3700. But in the subsequent ROP rules, although the post of HOD Polytechnic was included for revision of scale of pay. But inadvertently, the post of workshop superintendent, Assam Engineering College did not find place. As a result of which the petitioner is not being paid the required scale of pay as he is entitled. The aforesaid, from the aforesaid communication, it appears that it was an inadvertent mistake on the part of the finance department not to include the post of workshop superintendent of Assam's Engineering College in the ROP rules, which apparently requires a rectification. We see as no objection is raised. We also note that no objection is raised by the finance department that under the law, the post of workshop superintendent, which is a sanctioned post, should not be included in the ROP rules. In view of the same, the finance department is directed to do the needful to correct the inadvertent mistake of leaving out the post of workshop superintendent, Assam Engineering College, from the relevant ROP rules, and inform the court about the needful that have been done by the next returnable date, list on Monday.
Lordship, it involves the respondent authority in the higher education also because they are.
For doing the needful, the respondents in the higher education department should also cooperate with the finance department and provide them with any relevant material as may be asked for. But laid back attitude on behalf of the two departments cannot be a reason for an employee working in a sanctioned post not receiving the adequate salary merely because inadvertently the post had been left out while the ROP rules were framed.
35.
This Monday. Mr. Ask your department. Give them whatever. And if you have a good reason that why it should not be included, tell us. We'll hear it from a different point of view.
Time and again communicated to incorporate in the ROP law. You can string order to pass by the authority.
With direction to both the departments.
Not civil. All of it.
This is IA for interim order. Why financial power had been taken away? You are the writ petition, you are respondent or petitioner? Petitioner. You got an order of status quo. What do you mean by status quo? No. What do you mean by status quo? As it prevailed on the same date. What prevailed on the same date? You were the headmaster. Was he the headmaster on the day status quo was passed?
Take instruction, Lordship, order at page 13. In respect of headmaster in charge of the Keramat Ali ME School. Last time, no?
By which order you were taken charge? By which order you were appointed? Page number? Main case, just which page number? Page number 23. You are reminded that you will complete the age of to Hassan Ali. Who is Hassan Ali? Therefore, as per departmental procedure, request to retire from service after handing over all official to the senior assistant teacher. So by this order, you are the headmaster. Now, why did you come to the High Court?
After that, again, order has been passed under the same day, without cancellation this order, that is the base 30.
Page 30.
Have to be the base 30, and money plus base 30.
So Anwara Begum, who is Anwara Begum? No, somebody is claiming to be senior to you.
He claimed that he is senior.
Keramat Ali is senior to you.
He claimed that he is senior.
So why should you be the headmaster? Why not Keramat? Because the first order said hand over to the senior assistant teacher. So without determining who is senior, this retired principal handed over to you.
Yes.
Now the authorities came to realize that Keramat is the senior and not Anwara. So they asked Anwara to hand over to Keramat. So what is wrong with that?
I am telling that there,
On what ground?
I am the senior, in the Pavitra, he is not the graduate teacher, I am the graduate teacher of the school.
So
So them.
Keramat is not a graduate teacher. And qualification for headmaster, it's a graduate teacher.
No.
Mr. Kaushik?
No,
Is there a requirement to be a
No,
graduate teacher to
there's
be
no
a
requirement.
headmaster?
there's no requirement.
Then it doesn't matter whether he is graduate or not graduate. We'll have to decide this issue.
I submit the order of the.
No. Order now we'll modify. We'll modify to the extent that if you cannot point any relevant provision which will say that a non-graduate teacher cannot be a headmaster, then he, admittedly being the senior, he is entitled to be the headmaster.
Because the notification of 2nd of March 2010, your lordship, that lordship will file in the affidavit in opposition filed by the respondent number 5. Here, whether the post of headmaster is a promotional post on the basis of the seniority come efficiency.
Seniority come
Efficiency.
efficiency. Nothing to do with the graduate.
And he don't dispute that he is otherwise respondent number 5.
Fully established in the year.
Have you filed any application for vacating the interim order?
Actually, we filed additional affidavit in opposition, Lord, in the record.
Very well. Then I have to hear it.
And Lordship, one more thing, Lordship, that actually from the record itself, Lordship.
No, we understand, but
Stay vacating application filed.
No,
but if you are
yet.
not
Yeah.
filed, we cannot vacate the interim order, number one. But we clarify that if he is the headmaster, rightly or wrongly, he should be given all the powers. It cannot be that you'll give him a part of the power and other part will withhold.
Otherwise, Lordship, as per Annex
Third,
5
Mr.
petition, Lordship.
We are clarifying, giving the complete power, and if you are agree, file application for vacating the interim order. We'll hear you.
Actually, we have filed one.
We are convinced you have a good case, but you have not filed your application to pass that
We
order.
have filed the petition, Lord, challenging the first order.
File a writ petition. Then list it together along with it. We'll hear you.
Lordship, on the exact Lordship.
Till then will be hardly 2 days, not beyond that.
Yes.
The writ petitioner,
I think
applicant, relies on the order dated 6/3/2023 of the Block Elementary Education Officer Dolgaon, which requires the outgoing headmaster Muhammad Hassan Ali to hand over the charge of headmaster of the school to the amongst others, senior assistant teacher of the school. Accordingly, the petitioner Anwara Begum was handed over the charge. The communication dated 6/3/2020 is assailed by by another communication dated 23/5/2023 addressed to Anwara Begum. The block elementary education officer requires her to hand over the charge to the respondent number 5, Kiamat Ali. It is stated that as per the service records, Kiamat Ali is senior to Anwara Begum, and therefore, in compliance of the order of 6/3/2023, it is Kiamat Ali who should be the charge headmaster. The subsequent communication 23/5/2023 is assailed by Anwara Begum in WPC 3545/2023, wherein there is an interim order of maintaining status quo. The present interlocutory application is filed 260020 by Anwara Begum on a grievance that, in spite of the order of status quo, the financial powers of the school had not been handed over to her. We are clarifying that the order of status quo, based upon which Anwara Begum is discharging the duties of assistant headmaster, a headmaster of the school, does not in any manner provide that the financial power should not be given. From such point of view, we direct the respondents to also allow the petitioner Anwara Begum to discharge the financial, to also have the financial powers, as long as she is the headmaster. On the issue raised by Kiamat Ali, that he is the senior most and therefore Anwara Begum should not be headmaster and it is Kiamat Ali who should be headmaster. It is stated that WPC so-and-so had been filed by Kiamat Ali, raising the same issue. List both WPC E2 and 3545 and so-and-so on fixed date, on which date the matter as to who between the two should be the headmaster would be heard.
Right.
This conference. I disposed as indicated above.
Item 36. So I take it before you.
Builder prays for time to file affidavit, 4 weeks time to file affidavit. Have you filed your affidavit? Mr. Ian Harry prays for further 2 weeks time to file the affidavit, list after 2 weeks. Want to file affidavit? How much time? 4 weeks. He is 2 weeks, you are 4 weeks. How can he balance the two?
4 weeks. 4 weeks.
Both of them 4 weeks. Okay. Also
37.
4 weeks time to file on behalf of the UCC.
UCC now.
Yes. Service complete.
Entering appearance on behalf of respondent 5.
Turn up to Liho as entered appearance of your respondent 5 and praise for
Time to file the affidavit.
how much?
2 weeks.
2 weeks time to file affidavit, prayer law, this after 2 weeks.
38.
Mr. B. Chaudhary for the SSC, praise for 3 weeks time to file affidavit, prayer law, this after 3 weeks.
Last order, file their affidavit 524 on because the order for 11 months. That's the only.
Lots of 2 weeks.
Okay, 2 weeks.
I also.
So and so also praise for 2 weeks time to file respondent 6. List now.
39 for hearing.
But not the, otherwise this is covered by your lordship judgment. That might not the committee constituted by the university, that they cannot look into anything other than API.
On that Bilasipara.
Philosophy.
Same case.
That
Yeah, Lordship.
University will only make that APR
API,
assessment.
yes.
They will
Yeah,
not make the, not make the
The
selection.
API committee went into, acted beyond their scope, my lord. And I mean, they have taken note of the grounds which are not at all germane for their exercise. In any case, my lord, the points on which they wanted to have clarification, which I provided of, yet I was not called for it. They just stay order.
Lordship, so for the moment, Lordship, may kindly peruse Lordship the affidavit in reply filed by the Lordship petitioner. In page 191, Lordship. The reason is that Lordship is here very specific. He himself says that.
What?
He himself says that Lordship. If Lordship permit, I can read. Lord. In this regard, the petitioner begs to contended that he was informed by the respondent authorities that his earlier application along with the supporting documents of the year 2015 would suffice for his application for the post of principal of Dhemaji College of the year 2018. Hence, the petitioner in good faith and under bona fide belief following the instructions of the respondent authority did not submit the first application in the year 2018. Lordship. That push was for advertisement was done Lordship in 2018. Lordship.
Why was the writ petition
That is
filed?
not the reason, my lord.
Lord,
That's what it
if
appears.
Lordship, the particular petitioner did not submit the application from Lordship, how the university authority or college authority will examine it, Lord?
No, what is the prayer?
Prayer is for Lordship, on page Lordship, it's in page 11,
That
Lordship.
is not the reason, my lord.
Page 11, Lordship.
Why selection for the post of the held on by the selection committee and approved by the shall not be paused? Allowing the petition. Okay, petitioner is not allowed to
Lordship,
participate in the
Yes,
selection
lordship, now,
process.
Lordship.
initially, my lord, I think he can argue for me, my lord.
That's Lordship, sir. Ask me, that's why I'm pointed. out.
No, 1 minute. No. According to you, this prayer should not be allowed as because he had not submitted application. This is what I understand what you are saying. Yes.
Lordship, now today I am saying that Lordship may set aside the whole process and direct the authority to test advertisement because Lordship 5 years period is already completed. Lordship.
5 years period for
2018 advertisement was done, Lordship, for 5 years period, Lordship. That was already done. So Lordship,
where is the
and
advertisement?
Lordship, we are
Where is the advertisement?
Lordship.
Yes.
And lordship-
Is that page number, my lord?
Page 18, sir. Page
Eight.
18.
Of the
Eight.
report?
18.
And Lordship, college is suffering very lot, Lordship.
Definitely, we want
18, Lord.
Where is the relevance of 5 years period?
5 years, Lordship. Now it is for 5 years period, principal. And the end, Lordship, the eight. The term of the principal shall be 5 years as per government guidelines. As per UGC guidelines, it should be 5 years, Lordship. After
So
that,
had it been done on time also, 5 years would have
5
been
years
over
should
by
be done,
now.
Lordship. So Lordship may set aside, hold the process. Today I have no objection. Lordship may direct a test advertisement because Lordship college is suffering very lot.
I understand.
And
Mr.
NAG
Can
assessment is
we-
there also.
They have no objection, because I want to participate in this election on some erroneous ground, my lord.
We are suffering, Lordship, day to day suffering. Students also suffering.
For whom do you appear,
I am
Mr.
putting
Gurva?
governing body will respondent free, my lord.
You are also agreeing with it?
He has no objection.
No, will some other candidate come that we are
Lordship,
bona fide
other-
candidate submitted application, our case was not considered?
No, my
Lordship,
lord, actually, my lord, I was not, my case was not considered also ground, they have pleaded in their. But my lord, my certificate, there is some, they found some incongruity in my certificate.
Hmm.
Then the university.
The API.
They wrote to the authority.
That this man is not to be selected.
This is all right, and in fact, I pursued my studies
Huh.
and I passed out from the university.
Hmm.
There they do not take note of.
Hmm.
my friend.
And this is a new point, my lord, which my learned friend has argued.
Yes,
No, let
but-
us,
Lordship, as
Yes, my earlier I applied, that's why
I
I
am-
was given to understand that even that will.
I am on the basis of the record, Lordship. And my friend also no objection because Lordship already 5 years term is
For
gone.
whom do you appear?
Lordship,
who
he
is
a
he?
private. His name was recommended, Lordship.
You also don't,
Lordship.
you are also agreeing. Then let us pass a consent order. Heard Mr. Ken Chori, Land Senior Counsel for the petitioner, Mr. E. Gogoi, Land Counsel for the Higher Education Department, Mr. B. Burwa for the authorities in the Dhemaji Commerce College, and Mr. A. Chakraborty for respondent number 5, who claims to have been recommended pursuant to the advertisement available as Annex 3, page 18 to the writ petition. And Mr. R. Mojumdar for the respondents in the Dibrugarh University. Without going into the issues raised in the petition, it has been brought to the notice of the court that as per the Annexure 3 advertisement, the term of the principal shall be 5 years as per the government guideline. It is stated that due to elapse of time, 5 years period is already over, and therefore there is a requirement of issuing a fresh advertisement for the post of principal, Dhemaji Commerce College. All the parties before the court has agreed to the said proposition. Accordingly, as an agreed order, this writ petition closed by requiring the respondents in the Dhemaji Commerce College to issue a fresh advertisement for the post of principal of the college.
There's one thing, in case they again reject me on the same ground, that issue may be kept open. So that
In the event the petitioner is also an applicant to the advertisement to be made and is rejected on the same ground as raised in the present petition, the question for remedy for the petitioner to approach again shall remain open.
My lord, may
In the meantime,
No, if the order is vacated, he will become principal. That cannot be.
No. Lordship may direct us to fresh advertisement. We will do in the
by requiring a fresh advertisement, we clarified that the earlier advertisement shall not be acted upon any further.
Lordship may within a 2 weeks period, we will advertise. Lordship may indicate.
The advertisement be issued at the earliest in view of the statement of Mr. K. Goel and Council Higher Education Department that the college is suffering in the absence of a regular principal. The authorities in the Dhemaji Commerce College to take note of this said submission and act accordingly.
Almost 6 years. In January, it will be 6 years.
But before that, why didn't you sort out with the petitioner whether that is a good ground to be rejected or not? Again, the same will come up and one more stay order, 1 more 5 years.
Some lapses from all the sides.
Hmm.
The petition is also filed 2018 lordship. Interim order is.
As the petitioner has raised an issue regarding unacceptability of certain certificates relied upon by the petitioner, it is for the interest of all parties that if such certificates are again relied upon by the petitioner in the process to be initiated, before rejecting the claim of the petitioner, it would be in the interest of all the parties to give the petitioner a hearing and sort out the difference of view. Let him explain what he wants to say. You also.
And secondly, my lord, by lordship's earlier judgment that issue is open, that committee cannot go beyond appeal.
That part.
Basically, the committee took the decision. my lord.
No, we don't read that. That is already decided.
If lordship face advertisement, their issue is done, then lordship judgment is covered. There is no issue, lordship. Lordship.
I think 40.
Mr. Mishra was there in the morning.
Yes,
But
yes.
today it took some more time, I don't. That depends on the day always, what kind of matters are there.
Only problem is, my lord, next week I will be not there. So I think it will have to go beyond that. On the last occasion, the matter was not there. More part to baki hai, sir.
It's still work.
Now it has been done.
It is stated that the memo of appeal had been that all the pages of the memo of appeal, including the annexures, had been sealed. And the matter is ready for hearing. List on switch.
Madam.
18 December.
Let it be 20, madam.
20. As agreed, list on 20.
41, 42.
Yeah. 15 matter, what is this? No, why is it pending for 8 years?
Pending money. Sometime we came under with the part to getting this debt.
Dismissed for default, recalled, none appears. So what is to be done, Mr. Bora? As paid for list on switch. Raymond, to continue till the next day.
Supplementary for this item 43 to 47.
I think there is a personal appearance also, in some matter. In these matters,
Yes.
why did we order personal appearance?
But the issue came up before your lordship was that the private respondent whose initial appointment was as an assistant teacher, but she was provincialized as a language teacher. Lordship directed the DEO and the headmaster on the last occasion, but the headmaster did not bring the record.
Today the records are brought.
The records, he has brought the record.
How the assistant became a language?
No,
You
but
please find out.
there is no language post of language teacher as such in the ME school. The assistant teachers are given the duty. They teach.
There is no post of language, there is no post social science, there is no post of science maybe, because science needs a specific qualification.
In fact, Hindi also. So the assistant teacher, they are given the duty of teaching English, Assamese or social studies. He brings up some records of 2009-10, where the routine shows that the private respondent was always teaching Assamese language.
Language teacher. And Mr. Islam's client?
He is an Hindi teacher. There is no dispute to that.
Hindi.
Now the issue.
So he is Hindi from the beginning.
He is Hindi from the
And Mr. Saikia's client is also entrusted to teach Assamese.
Assamese.
In the year?
Since 2008.
2008. When was Mr. Islam's client appointed?
Islam's client, my beloved friend, Mr. Islam's client, he is senior.
No, he is appointed on?
Appointed on 1992.
1992. And Mr. Saikia's client is
Appointed in 2008.
2008. As a
assistant teacher.
No, and entrusted with teaching Assamese. So language teacher.
Language.
For the purpose of the act, language teacher. Now, who should be provincialized as language teacher?
No, that issue, there are connected repetitions, where this issue is pending, that among the Hindi, whether Hindi would be included in the language or not.
If Hindi is not included, they are out forever. And if Hindi is included,
then
it will be a grave inconsistency that for a subject which will go up to class 8, you'll have a good provincialized teacher. And a subject where the candidates will appear in matriculation, you'll not have a good provincialized teacher. How do you balance the two?
But the structure of the school in the ME school, 3 language policy, we have adopted a 3 language policy where Assamese, Hindi and
No, we understand that.
till class 8, these 3 are compulsory.
No, but a student in ME section, when he progresses further, he will undertake matriculation exam. That's a final examination. He will undertake higher secondary examination. That is even a further examination. And the marks obtained has a lot of value, at least in higher secondary. Which institute he'll be admitted, where will he not be admitted, depends on the marks obtained. Now, if Assamese is one of the subject where he is required to appear, and during his growing up period in ME section, he is taught by a teacher who is not provincialized. We understand that there is a direct nexus between a provincialized teacher and a good teacher. Okay. If he is provincialized, a good teacher will remain. If he is not provincialized, good teacher will go out somewhere else. Somebody else will come and do the work. So, in a subject which will have its effect in the career of a student in metric and higher secondary, will be taught by non-provincialized students. If the Hindi teacher is declared to be also a language teacher. On the other hand, he is also a teacher and he is also a language teacher. He's also, but at the same time, that will forever oust the Hindi teacher. So your other requirement of your education policy to have Hindi up to class 10 will, 9 will, 8 will also be frustrated. Will not have good Hindi teacher. When a Hindi teacher knows that I'll never be provincialized in my entire life because the rule itself doesn't provide, Why should I go to teach in these schools?
My lord. In fact, my lord, that is in respect of looking at it through the student's perspective. In fact, this in the teacher's perspective also, my lord, when this recognition to the schools were given, Hindi was a criteria for giving the recognition. So under such circumstances, when the recognition is taken up for provincialization as a criteria, eligible criteria, in such situation, my lord, leaving out
No,
the
we
Hindi
understand.
would also
We
personally deprive
understand
that.
that requires the legislature to give us fresh, separate consideration what we want to do with the Hindi teachers.
That perhaps, my lord, the affidavit which we have filed in that, the connected reply. Your lordship takes up that issue, my lord.
I think let us.
My lord, that clarity.
But otherwise, you see, technically speaking, language means it's a medium of expression. Hindi is also a language. Assamese is also a language. So definitely, when one language teacher, Hindi is, you cannot leave out Hindi. You cannot leave out Arabic. Similarly.
Similarly, in ME Madrasa,
But
Arabic.
will it, in the long run, will it have a good impact on the other right to education of the children?
Because
every
section-
aspect we can't look it from the point of view of the benefit of teachers.
Yeah.
Teachers are there for the benefit of the students.
Benefit of. And RT
So
Act-
what kind of order you expect us to pass?
Well,
See, we have
regarding-
analyzed the whole
yes,
thing and
regarding whether the Hindi and Assamese or the other language, whether it would be inclusive of all language and whether there can be any restriction of provincializing only one.
on which day you want, let us hear this issue then.
Your lordship, let your lordship.
Hmm.
Our affidavit is on record.
On which day you want? Why these are listed for motions?
This matter was for list, motion matter,
Not the others.
not the other.
I have another matter. There's another act, Assamese language, compulsory military, in 28.
Assamese
You are for the Assamese teacher.
I am for yes, but it makes the Assamese color compulsory subject. If all students accept all of these schools in
Let us settle this issue whichever way you go, so that at least you go in appeal and the matter is carried further. Unless you don't do anything, it will remain here only.
But this case is concerned, he has been the similar madrasa, ME madrasa, and Assamese is a compulsory subject. Therefore, this Assamese comes, but he is concerned, he has been shown as an addition. That is there.
No, we are not going to this additional business. We're going to straight at the core issue. Whether the expression language teacher in section 311, 3111 of the Act of 17, do we include a Hindi teacher or it does not include a Hindi teacher? Let us
In
touch up
fact,
that
that
issue.
was the query which was raised in the petition.
Hmm.
And responding to that, we filed the application, well, the affidavit.
Hmm.
But that in the disposed petition, well, that issue was not decided.
Hmm.
So that issues remain pending.
And you also obtained a view of the department, which one you want? Moment you include Hindi, you are doing a good service to the teachers. They are working for a very long time. What about getting a good teacher for Assamese subject, which will be a subject for the students in matric, higher secondary, etc., and maybe in graduation also. So if this man is weak in Assamese because a good teacher was not teaching in the formative stages, that student will suffer.
The
In the
understanding by the authorities of
later
3111
years.
is confining it to one language.
Mhm. I think there is a lacuna in that act. We'll send it, ask the government to send it back to the legislature to take a decision on this one. If the legislature takes a decision, no, Hindi is a language and there is only one subject, irrespective of what happens to the Assamese knowledge of the students for future, it's for the legislature to
Same
take.
confusion has arisen also for the Arabic.
Arabic, same thing, Hindi or Arabic. And if you feel not this being a major subject which will have a effect of marks obtained in the later examination, which will affect the service career of a student, you take your call, let the legislature take a call.
my lord, take on 7.
7th.
Otherwise, that affidavit, my lord, is indicated. my lord.
In the meantime, you also have a discussion
I'll
with the
have a
authorities, what they feel.
My lord, I'll have.
You want it on 7th?
Or any day.
No, let it be on 5th.
5th, no problem.
Mr. Islam, you also prepare why Hindi should be, other than saying Hindi is also a language, why Hindi should be included as a language under 3111.
3-1.
The dictionary meaning and the meaning under 3111 will have to segregate and deal it separately.
But the language not even my lord. It is a matter of languages. Three teachers, one for my lord science and math, other for social studies and languages. What is language? Not language.
We know, you have stated that. That languages means English and Assamese possible.
It's not
Suppose what we are a little concerned is a school has a very good Hindi teacher.
Right.
The student will read up to class 8, then forget about Hindi. And the student is very good in Hindi. School is not having good Assamese and English teacher because of this provision. The student will face all the later final examinations where the value of the marks will have bearing in his career. But he'll not be taught by a good teacher.
And vice versa situation.
Hmm.
And the school doesn't have any Hindi teacher till class 8.
Hmm.
And the Assamese and English teacher, they are not competent enough to teach Hindi because having not.
So Hindi being a class apart, I think Hindi should be decided separately by the legislature whether you want to provincialize or you don't want to provincialize. Rather than keeping it tied up with this one.
And that uniformity is not there because in some districts, Hindi teachers have been apart.
Because the issue was not decided.
Not decided. I think this.
Wherever, depending on the decision of legislature, wherever Hindi already provincialized, you reverse it.
Right.
Give it to a regular language teacher. Hindi you provincialize as a Hindi.
I'll have a discussion with your partner.
Otherwise, what to do? And think of something else.
Yes, otherwise the seniority dispute is not an issue. Had that been the.
No, seniority you can decide that provided this thing. There also the same question comes.
Yes.
Even if it is there. And they are writing many number of petitions pending on this issue.
Several. Either concerning Hindi or Arabic.
What do you do? We want to send it back to the legislature. You take a decision. We'll only frame the aspects that are required to be looked into.
Right.
Okay.
But the headmaster has come, his personal appearance, whether it is.
The headmaster of so is present for the court along with the records. The records reveal that the respondent number 6 was appointed as an assistant teacher, but she was entrusted with the responsibility of teaching the Assamese language all throughout since her initial appointment. Having taken note of the aforesaid factual situation, for appearance is dispensed.